Welcome, everybody. Justice is a Process is here, and we today are going to be watching the Brice Rhodes trial. We're going to be watching day 5. It comes on starting at 12:30. It comes on starting at 12:30. So we will be in for that here in just a moment.
I hope so. Sure. Where is? Do you know where the best place is for everybody? You mean like an easel board, right? Maybe right here in front of. I mean, I don't care where you put it, but maybe right here in front of the bench. You know, it's like you don't want to be too far; they can't see it. But then you want guess what? I don't know. Does your witness need to see it too?
No, I'm just gonna write.
Okay. You talking about me?
No.
I was like, I mean, I don't need to really see it unless I have to.
You see it?
I mean, you all can also move around. I was going to say, if I need to see it, I'll just come down there.
What do you think? Is it too far away if we move it back a little so I can still see it? Is that okay? We too bad. Knock yourself out. But as long as the jurors can still see it. I get paid.
Out of state, sir. Out of state.
Submit your invoice.
I mean, see if they say no.
They've been, they've been staring things up there, so.
Sure.
All right, they can come on in.
All rise for the jury.
You guys are pros now. It's great.
All 15 jurors are present, Your Honor.
Sure. Sure, take your time.
That's it.
You all can all sit down if you'd like.
Who else needs one? Somebody else needs one?
Anybody have anything that they need to report or talk about? Okay, great. Ms. Jones-Brown, are you prepared to call your next witness? Thank you. Good morning. I'll go ahead and raise your right hand. Do you swear to tell the truth and the whole truth? Thank you. You can have a seat.
Good morning. Could you tell the jury your name, please?
My name is Lauren McCann.
Where do you work?
I'm employed at the Central Forensic Lab, which is located in Frankfurt.
And who runs the central lab?
It's all the laboratory systems are under the Kentucky State Police.
What sort of education and training do you have for your position?
So I have a bachelor's of science in forensic science with an emphasis in biology from Eastern Kentucky University. Upon being hired at the laboratory, I underwent extensive in-house training under qualified analyst and the technical leader at the time, doing written exams, oral exams, observing casework of qualified analyst, as well as being competency tested in each bodily fluid.
How long have you worked at Central Lab?
8 years.
And what is your position title?
I'm a forensic scientist specialist too, and I test items for the possibility of bodily fluids such as blood, semen, and saliva.
Did you receive items of evidence in this case in 2016?
Yes, I did.
And what did you receive? Yes.
So I received a blood standard from Larry Ordway, a blood standard from Maurice Gordon Jr., a buccal standard from Christopher Jensen, a buccal standard from Lenny Frazier, a buccal standard from John Lyle, a buccal standard from Emily Sutherland, a buccal standard from Brice Rhodes, a buccal standard from Anwan Carter, a buccal standard from Ja'Cory Taylor, left-hand fingernail scrapings from Larry Ordway, right-hand fingernail scrapings from Larry Ordway, a leather strap from Larry Ordway, right-hand fingernail clippings from Maurice Gordon Jr., 2 knives, 4 pieces of carpet cuttings, 2 carpet padding cuttings, a blanket, pillow, a towel, sheet, carpet cuttings, a sock, a latex glove, washcloth, and paper towel, a Nike shoe, a Reebok shoe, an Air shoe, swabs from the front driver's side interior door of a Mazda, swabs from steering wheel of Mazda, swabs from gear shift of Mazda, swabs from front driver's seat recline lever of Mazda, swabs from interior rear driver's side door handle of Mazda, swabs from rear passenger side interior door handle of Mazda, swabs from front passenger side interior door handle of Mazda, swabs from front passenger seat recline lever of the Mazda, swabs from driver's seat back near the headrest of Mazda, swabs from interior door seal, rear driver's side door of Mazda, swabs from rear passenger side floorboard of Mazda, and Timberland boots.
Write some of these down. How do you and LMPD work to ensure that you all know what each other is talking about?
Sorry.
Are there numbers
Oh, yes.
associated?
Yeah, so the agencies always have their numbers of the items that they collect, and then when it comes to the laboratory, they're given unique identifier numbers and a lab number when it comes into the laboratory. That way it's tracked through the laboratory system.
So,
So my numbers will look a little different than.
for instance, on the carpet cuttings, is there an LMP number and a lab number for those?
Yes.
What would the LMP numbers be?
So for the carpet cuttings, I have 63A, another carpet cutting 63B, another carpet cutting 63E, another carpet cutting 63F, and then I've got carpet padding cutting 64B, another carpet padding cutting 64C, and then carpet cuttings I have 75.
So when we're saying 63 A, B, C, does that mean they all came from what started out as 63?
That would have been the number that from the submission form that it was assigned from the law enforcement agency that submitted it.
When you receive items, what state are they in? How does LMPD send them to you?
Yeah, so we have a quality assurance standard being at the laboratory. Every item that comes to the laboratory is properly sealed based off of the qualifications in our quality assurance manual. And so what I mean by a proper seal is it will be taped so that there's no openings. And the person that was last either opened the item would put their initials over the tape.
When you received the items in this case, what did you do with them?
Yeah, so when I received these items and pulled them from the freezer, I performed serological analysis.
And what does that mean?
Yeah, so it's the identification of bodily fluids such as blood, semen, and saliva.
How do you do that?
Yeah, so for blood testing, there's two different tests at the laboratory. I'm going to explain the test first. We have a presumptive test, which what I mean by a presumptive test, it's a test used that a positive result is a good indication that a bodily fluid is present. If that result is positive and there's enough staining present, I can take that sample forward for a confirmatory test, which conclusively determines that bodily fluid to be present. So when I'm opening an item, I'll do a visual examination and look for any possible staining that could possibly be blood. I then would perform that presumptive test. The presumptive test is looking for a component found in blood, and in the presence of this component, it turns a swab a pink color. The absence of that pink color is the negative result. And then if that sample is positive and there's enough staining there, I can take it forward to that confirmatory test. And it's similar to a pregnancy test. A portion of the sample is added onto a card, and 2 lines will indicate a positive result and 1 line will indicate a negative result.
Okay. And so for all these items, did you go through and do a presumptive test and then move on to the next test?
So we'll open, every item is opened separate from other items. So each item, if I did perform the presumptive test and wanted to test it for the confirmatory test, it would have been done right after.
And is it your role to test these items against the DNA submitted by known persons and to conclude
people's DNA is on the items?
Yeah, no, so I just test for the possible presence or absence of bodily fluids. And then if I have any positive items, send it forward for DNA analysis.
And does another analyst do the next step?
Yes.
Okay. So I want to go through these items. Let's see, you tested item 20, the strap. What did you find?
So I have, presumptive testing for blood was positive on item 20, the leather strap, but the presence of blood could not be confirmed through further analysis.
Okay, so presumptive. Oh, so what does that mean?
So I have written in my notes that the staining, so whenever I'm testing an item for blood, if there's not good transfer from the swab, from the item swabbing, I'm deeming it QNS hemotrace, which is our confirmatory test. So the quantity was not sufficient. I didn't want to consume any more of that sample from a preliminary standpoint and sent the sample on for DNA analysis.
And did you do any testing of the fingernails of either victim?
I apologize, I misspoke. Sorry, I did test this one with hemotrace. I'm sorry. I did test it for the confirmatory test and it was negative. I apologize. The strap.
Okay, so presumptive positive but not for the confirmed.
Yes, that is.
Did you test the fingernails?
No, I did not.
Did you send those off for testing by somebody else?
Yes, I did.
Let's see, the next on the list is the H knife. What did you find on the first knife?
No blood was found on the knife.
And then on the next knife?
No blood was found on the knife.
Did they send you the actual knife?
Yes.
And so how do you determine what's what?
Yeah, so I would open the items separately, and the entire item will be tested. So I will test for the possible presence of blood. If I do have a positive result, I can then take swabs from the handle for owner-user swabs.
Looks like the next on the list is carpet cuttings. And I only wrote down 2, but you actually had 4 different carpet cuttings, correct?
5.
You had, was it 2 carpet padding cuttings?
Yes.
And 2 and 4? Or 5 carpet cuttings, sorry.
I have 5 listed on my.
So for the group of carpet cuttings, we'll get to the carpet paddings in a second. What did you find on those? I think the first one would be number 24. Numbers.
Items 24, the carpet cutting contains blood. Presumptive testing for human origin was positive. So I took it forward, that presumptive test was positive, and then took that sample on for the confirmatory test.
So presumptive positive, and what happened with the confirmatory test?
It was positive as well. So it confirms that blood is present. However, our test at the laboratory is presumptive for human origin because our test cards can also test positive for ferret blood, human blood, and higher primates.
Ferret blood?
Yes.
So I am on this chart going to circle in red when it is confirmed.
Okay.
To distinguish from the unconfirmed. What was the, and so when you confirm blood, is that the end of your analysis of that item?
Yes.
What happened with the next group, 25?
Presumptive testing for blood was positive on item 25, the carpet cutting. So it was just positive for that presumptive test.
Hold on. So we are going to actually go ahead and argue instructions. So I'm going to tell you what's going on. Okay, perfect. And then I actually have to come back and get that one.
All right, guys. So we are here. Trial has started live, and it looks like a juror just got dismissed. So we are waiting right now. It appears, I believe, they're going to be moving into, it looks like, closing arguments, I believe. I don't think the defense is putting a case on, but I guess we'll find out. But that's what it sounded like to me.
So when we were here last week, I indicated to counsel for both sides that generally with instructions, what I will do is look to see where they're different and go through them that way. However, because I did not get instructions until this morning, I have not had time to do that. So, I'm just going to kind of go right into it. All right, let's look at the Commonwealth's instruction with regards to the defendant's instructions with regards to presumption of innocence. Is there any objection to that inclusion?
I have the same.
Hopefully it's the same.
It appears to me to be the standard Cooper's instruction for presumption of innocence. It's this. I'm looking at the defense's version of instructions, their first page of actual instructions.
I have it under instruction number 8, but it's the same.
Oh, do you?
Yeah.
And so then does the defense have a position on whether it comes before or after the instructions as to the various counts of the indictment?
Judge, I don't know that the court is compelled to do it one way or the other.
It doesn't matter to me.
It's our preference that it go first.
Okay. And then the Commonwealth also included a definition for unanimous verdict. Do you want that included as well?
That's fine. I wasn't sure. I couldn't remember. I thought I did have that
Maybe you have it at the end.
near the end, right before
That's fine.
the-
We'll just continue going through yours. All right, definitions. Are you all aware of any differences in your kindred definitions?
Yes, there are a lot. The Commonwealth is only asking for an instruction on intentional murder. So that cuts out a lot of the definitions that we submitted. We submitted definitions on intentionally, complicity, and official proceeding.
For the defense,
Judge,
what is the basis for including wantonly or recklessly?
well, Judge, the indictment says wantonly in it on all 3 of the murder counts. So based on the actual charges themselves, we thought that it should be there. There wasn't any amendment, nor do I think that we would object at this point to an amendment of the indictment or of the charges.
I don't think recklessly is in there.
No, I was
Okay, but just
specifically
for
referring to
wantonly?
wanton.
Okay.
Judge, we are asking for lessers, and I don't know if the Commonwealth appears not to have proposed those, but it is our motion as part of our proposed instructions to ask for lesser includeds, which would include manslaughter in the first, manslaughter in the second, reckless, which are the standard lessers on any homicide, and then also based on the evidence that's been presented, as well as the deals that were offered to the co-defendants, we believe that facilitation should be an option for the jury.
All right, just a moment. So as to wantonly, I think based on the charge, wantonly should be included, but does come with any objection to the wantonly definition being included?
We do, Judge, because there's been no evidence presented at trial that would support anything but intentional in this case. I realize their defense is that he is not the one who did it, but the evidence at trial is that these.
Can I tell you what my concern is? My concern is that without wantonly, the jury would not be able to find that even if the purpose wasn't to intend to kill, that it doesn't fit under intentional murder instead of wanton.
If the court is going to give a wanton murder, then we would request that it be a combination instruction, as is allowed under the law.
Can you tell me what you mean by that?
I'm sorry, an instruction that's on one page says.
Oh, yes, that's what I'm talking
intentionally
about.
or wantonly, instead
That's
of
what
two
I
separate
that's
pages.
what I was referring to as the indictment reigns.
Yes. And the courts have commonly found that throughout the years that is a proper instruction, and that it is proper for a jury to find, if they are considering intentional and wanton, that it could be under the facts of the case, that some could find intentional and some could find wanton, but it is still a unanimous verdict.
Judge, we respectfully disagree with the Commonwealth under the facts of this case. One of the issues, Judge, the Commonwealth's proposed instruction does not have that. We did propose a separate wanton murder instruction, but the significance there is that the penalty results would potentially be different. So for a jury to reach a conclusion and have us not know whether they found it to be intentional or wanton prevents us from knowing how to proceed in a possible penalty phase. And I can go into more detail about why.
I mean, it doesn't. It might change your strategy, but it certainly doesn't prevent you from being able to do that.
Judge, if in fact the jury found guilt under a wanton murder instruction, then it would no longer be an aggravated murder, and therefore 2 of the possible penalties would disappear. So that's a pretty significant difference.
Is that correct? I didn't think that was true. If they found wanton murder, not manslaughter, not just wanton murder.
I believe, Judge, that under the aggravating statute, 532.025, and I'm going to pull it up, but
Thank you.
I don't expect you to take my word for it.
No, I mean, I do understand that you know what you're doing.
That the aggravating factor requires multiple murders that are intentionally committed.
I see. 532.035 is repealed. Ms. Jones-Brown? Oh, you're looking too? Okay.
So, it's 532.025 2 for the specific one.
Oh, I see.
Number
Aggravating or
6.
mitigating circumstances.
Yes.
Well, to that, I would say, Judge, that the law does allow a combination instruction. I understand their point as to penalty. I would think that a way to cure this would be to ask in penalty, like to make that part of the penalty phase instructions if we get to that point, so that they could
Yeah,
not
we've done that
impose
before.
the aggravator unless they have found that it was intentional.
It seems like it's inviting confusion, Judge, to give them instruction that defines murder and the actions in one phase one way, and then defines it differently in the second phase.
Well, it's not defining it differently, it's just splitting up the definition.
Yes, if we're comfortable with that in the second phase, I don't see why we wouldn't be comfortable in the first.
To split up the instruction invites the possibility that you could have 6 jurors who believe this was an intentional murder, 6 who believe it was a wanton murder. They're not unanimous on either count 1 or count 2 under the proposed instructions. Therefore, they can't sign either of those jury forms, but all 12 believe that this was a murder. That's not the state of the law. The state of the law is that it is a unanimous verdict, even though some might think intentional and some might think wanton.
And we would respectfully disagree that that would be appropriate under the charges in this case, and specifically under the wording of the indictment, counts 1, 2, and 3. I can say, Judge, a lot of courts do give, the separate instructions just for the clarity, just so we all know.
And the Commonwealth objects to, like, intentional or wanton.
I mean, it is our
Separate
preference that
instructions.
this just goes forward unintentional. But I understand what the court's saying, so I'm not objecting to the wanton. I am just asking for it to be a combination instruction, and then on penalty, they would have to find beyond a reasonable doubt that these murders were intentional to get the 2 aggravated possibilities.
That is, in fact, how we did it last time, and there was just a case published that talked about that being appropriate.
I apologize.
We did that for, like, are you finding it to be a violent offense?
I see the analogy, though I don't know that it necessarily is controlling in our case, Judge.
No, I understand. All right, I'm going to come back to, I'm going to do one or the other. I'm either going to do a separate instruction for wanton or combine it and then ask the jury to make a finding and sentencing as to intentional or wanton. Let me come back to that after we've talked about other lessers.
Yes, Judge.
All right, so what is the defense's position as to why a facilitation charge should be included?
Judge, I believe that the evidence itself has, the Commonwealth is asking for a complicity instruction, and if we look at the definition of complicity, which we included in our definitions, and the definition of facilitation, you can see how in any complicity case, facilitation is raised, and in particular in this case, there has been more than a little bit of evidence suggesting that Mr. Rhodes may have been present and may have participated, but may not in fact have been the one who caused the deaths. And that is classic facilitation. The Commonwealth has sort of forged a trail for us by the manner in which they've dealt with the 2 co-defendants, where they concluded that in fact their actions, even though they were involved and present, merited a facilitation result. It is our position that the facts as presented at a minimum allow the jury to potentially reach that result for Mr. Rhodes.
The Commonwealth objects, Judge. The way that the Commonwealth and various defense counsel choose to settle co-defendants does not then bind this court who sat on this trial and heard this evidence as to any certain theory. There has been no evidence in this case that the defendant was present but didn't do anything and just allowed it to happen. The evidence has been, this is sort of an all or nothing. He either was there directing all this and participating in this, or he wasn't. So facilitation is more of a disinterest in the outcome, which is distinct from complicity, in which somebody is engaged in and participating with a view towards the outcome that happens.
Judge, if the Commonwealth thought that the only issue on the table was an all or nothing, where Mr. Rhodes had actually committed the act, then complicity wouldn't be part of their instruction and part of their indictment.
I don't believe that there has been any evidence put forward other than a theory where this was Brice Rhodes' idea. So I don't think a facilitation instruction is appropriate. In that case, because of that, and because I just don't believe that from the evidence that's been presented, any juror could find that Mr. Rhodes' actions were facilitation. I think he's all in or nothing on that. I'm going to deny that instruction. First degree manslaughter.
We believe that the evidence, that a reasonable juror could conclude that there was an intent to injure and seriously injure, as defined by the statutes, without an intent to kill, which is a classic manslaughter in the first result, Judge.
And can you tell me any particular evidence you point to in reliance on that?
Yes, Judge. And again, we're talking about the role specifically of Mr. Rhodes. The discharge under the evidence of what appears to be a single shot is not necessarily an intent to kill. I'm not in any way saying that Mr. Rhodes was holding the gun or pulled the trigger, but I'm saying whoever. I don't think that that's sufficient to necessarily automatically amount only to and as far as Maurice and Larry.
Okay. And as for second degree manslaughter, same question.
Well, Judge, we believe that the Commonwealth's indictment listed wanton murder, and the court has indicated the intent to go forward with instructing the jury on wanton murder. Manslaughter in the second degree is almost identical to a wanton murder and is contained within a wanton murder. The difference is what is the additional element of manifesting extreme indifference to human life. That is a nebulous concept that I think lies with the jury rather than us. And I believe that if a reasonable juror could find a wanton murder, that same reasonable juror could find manslaughter in the second degree.
Commonwealth, what is your position on both first degree and second degree?
Judge, I don't think that there's been any evidence in this case that would allow a first degree murder. The evidence that has been presented is that the intent in going to 41st Street was to kill somebody with a price on his head. The evidence is that he stated that intent.
Hey guys, this process right here is extremely important. What's happening, and the judge's denial of facilitation is a huge ruling, because essentially the defense was hoping to be able to argue to say, hey, these guys get facilitation, they're getting 20 years. Some of them are already out of prison. Why does Brice Rhodes get more? Especially when you have to believe these guys and rely on their testimony, and it's not clear who did what in that room. So give everybody facilitation. So now the jury is going to have to struggle with the idea, do we release Brice Rhodes or convict him of everything?
I feel like the instruction's wonky though.
Not intentionally so, Judge.
I know.
Just one
I'm sure.
Yeah, I think so. And I have a copy of Cooper's that is.
I've got it.
There's another instruction in there that says and wasn't. It has the optional and wasn't in self-defense and stuff like that, but that doesn't apply in our case.
Actually, Judge, in Parker versus Commonwealth in 2007, so this wasn't even recent, with the wanton murder instruction should come instructions on lesser included offenses, notably here an instruction on second-degree manslaughter.
Does somebody have their phone playing something? I keep hearing some like video playing or something. Okay. Yeah. It was just I was just looking at the wrong one. Okay. So I think that this second degree one, the way it's written, is fine. So shooting him with a firearm and acting wantonly, it does match up perfectly with Cooper's. I was just looking at the wrong thing. Sorry about that. Okay, in reading the second degree manslaughter instruction, well, let me also hear any arguments regarding the reckless homicide and what evidence you believe supports a reckless homicide instruction.
I'll be honest, Judge, I didn't read any case law that required it. I'm used to it being given when a man two has been given. Usually they sort of go hand in hand. They have a lot in common as far as the mens rea and issues like that. So we proposed it, but I'm not aware of a case that requires it. We think it would still be appropriate along with the same argument basically as the manslaughter in the second degree.
Unless the Commonwealth wants it included, I'm not inclined to allow it. Okay, I'm going to deny that. I don't think the evidence supports that. And then that also means that I'm looking at removing recklessly from the definition.
If you're looking at the definitions for the defense, Judge, I think you had excluded manslaughter first, which means EED shouldn't be in there.
I did not include manslaughter first.
No, exclude.
Oh, yes. Okay, thank you.
So I was just saying, there are other definitions we can take out.
Facilitation can come out. Well, I guess I'll come back to that because we haven't gotten to the other instructions. I think that's it for now. Okay. All right, let me not get these all out of order. I really wish these were page numbered.
I'm sorry.
It's okay. I just might.
But if the page number, Judge,
Lose
and we
track.
take one out, then we're all confused because the page number.
There we go. All right. Now, here's where I need the defense to tell me what comes after the reckless homicide instruction as to Christopher Jones. Is it more Is it like another presumption of innocence, or does it go straight to intentional murder?
I think it goes straight to the next count, Judge. Count
Okay.
2.
And that is the intentional murder as regards to Maurice Gordon.
Yes, Judge, I believe so.
Ms. Jones-Browning, objection to how that's written? On the reckless homicide, since I'm not allowing it, I think that because there's going to be the second-degree manslaughter charge, to me it makes more sense to have one instruction for intentional, one instruction for wanton, one instruction for manslaughter. So that during closings, you're able to explain to the jury what the differences are.
I agree with the court.
Rather than trying to explain those differences later. If it was, if we weren't also having the second degree manslaughter put in there, I think I would think a little differently about it, like decide later. But I think as long as they're going to have to decide for one act, and then Act 2, and then Act 3, for as long as they're going to have to decide each one already, why not just have them go ahead and decide it based on a separate instruction for each one?
And this might not be the case where it really matters, but theoretically in a case where a jury is having trouble deciding intentional or wanton, how does that scenario account for the fact that they are allowed to convict on murder even if they disagree on the theory?
Mm-hmm. Yeah. Yeah, that's a good point. You all want to add anything on that for the defense?
Judge, I think that's raising an issue that is an unlikely event. I think the more
Famous last words.
Yes,
Dr.
Judge, it is
Griffiths.
famous. I think the more likely result is we understand these. Hopefully, we understand them pretty well, right? I think that they're confusing to the average person, and setting them out with separate instructions is just a lot clearer to the jurors and makes a lot more sense to the jurors.
It might, and I understand that, but I agree with the Commonwealth. I think it's too great of a chance of them not understanding and not knowing. If some of them think it's wanton and some of them think it's intentional, we'll be in a rough spot.
Would that be? Could that be resolved by an additional instruction or an admonition?
It could, but I don't really see the point of that. But I guess the question for me really is, should we have a separate instruction after that, like if you have found the defendant guilty under instruction number blah, 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 do you unanimously agree it was intentional? And go ahead and knock it out prior to sentencing.
I think that would. I think that would work, Judge. I think that
Okay.
would fix it.
All right.
So
And I'll
that-
go back and look at that other one we did for how we put that in there, and I'll let you all know what it is.
Okay. And would that then go sort of near the end, by
Yeah.
one of the last ones?
It'll be like the intentional or wanton instruction, and then the next one, if you found guilt under the last instruction, and then the language, do you believe it was wanton or intentional, and then very next thing, if you did not find the defendant guilty under instructions 1 or 2, you may find him guilty under instruction 3 if and only if for the second degree manslaughter.
Are these going to be numbered like 1A, 1B for murder
Yeah.
and Mansu
Yeah.
for Christopher Jones?
Yeah,
and then
I'll
2A,
rewrite 'em
2B,
all.
3A, 3B?
Yeah. And so, go ahead.
Oh, I was just going to say, we tried to do that. Like the ones I have at the back, Judge, are by count, and that may satisfy what the Commonwealth is talking about.
That's how I'll do them. I'll do them by count.
Yeah, 'cause I think if you do A and B, it helps the jury not find him guilty of both. Not.
All right, let's move on as to the count with regards to Maurice Gordon. Are anybody's arguments any different? If not, I'm just going to rule the same on each one.
No different.
The only different, the facts are different, obviously, Judge. I think Maurice Gordon and Larry Ordway, those two are pretty much identical as far as the arguments go. There is additional evidence regarding actions of multiple people rather than a claim of actions of a single person.
Okay.
Which I think would justify the facilitation instruction on count 2 and count 3.
I understand. Ms. Jones-Brown?
I don't have any additional arguments to what I've already made. And we would continue to object to facilitation.
So from my perspective, the testimony, there was not anyone whose testimony supported an idea that that Mr. Rhodes was facilitating someone else in committing those crimes. Can you point me to what you would rely on?
Specifically, Judge, just the testimony that literally said things like everyone stabbed, rather than just.
Well, the testimony I heard was like, Brice made me also stab. Was there a witness who testified to something other than, being told to stab the person after they had already been stabbed?
Even the witnesses who testified that 2 other people that weren't here, that we never saw, one who was identified, one who was not identified, also were involved and also were stabbing. And both of the witnesses called with the Commonwealth said that 2 other people stabbed both of the victims in count 2 and 3. So we believe that would also support a possible verdict of facilitation rather than.
Okay. I do not believe that any evidence that was produced would allow the jury to find Mr. Rhodes guilty of facilitation to murder or first-degree manslaughter for the same reasons, that there was not any testimony other than testimony that it was his idea, that he was directing the actions of others. Do we need to make additional record with regards to Larry Ordway, or is it the same argument?
Same argument.
Okay, same ruling. And then we get to tampering. Are your all's tampering instructions the same?
They're largely the same. They just have evidence. I listed some items of evidence.
I don't. That's fine, Judge. I don't.
I'm relying on the case. Hackett versus
If
Commonwealth.
that's fine. That's
Yeah.
I'll use yours as it is.
I do want to change, have an amendment to mine. I would like it to say and or instead of and. I believe that the jury could find any one item was tampered with and it would support this.
Oh, you mean on the final line of A?
Yeah, so it would say
Yeah, I gotcha.
and
Or the
private
back seat of the blue monster. I'll allow that. Okay. And then abuse of a corpse. Looks like they are largely the same, although the Commonwealth is a little more like fact, just barely a little more fact specific.
We don't object, Judge, to the Commonwealth.
Okay, we'll do that for each of them. Okay, so now we get to the other instructions. Let me briefly go back to definitions. So the Commonwealth's definitions are just intentionally, complicity, and official proceeding for the defense. Intentionally, wantonly, physical force, deadly physical force, serious physical injury, and complicity.
I think we can get rid of the serious physical injury due to, that was for manslaughter in the first degree.
That's
Okay.
correct, Judge.
And so I think I could then just add in official proceeding. So the definitions would be for intentionally, wantonly, physical force, deadly physical force, complicity, and official proceeding.
I think that's right. I didn't put in official proceeding, that's my fault.
What is the physical force and deadly physical force from? Where is that?
Deadly physical force. You know, I think that might be from,
That might be a man one.
that's what I was thinking.
I believe that's why I put it in there.
No.
I think it's from extreme emotional disturbance. So removing that due to removing man one.
It is. It
What's
is.
the need for that?
Okay. So then add in official proceeding. Okay. All right, and then at the end of each individual instruction, the Commonwealth has presumption of innocence, which we're putting at the front. We won't need it there. Both of you have unanimous verdict. Let's see. Okay. So let's talk about this right to remain silent instruction. Any objection to that?
I have it at the end of presumption of innocence, but I don't object to it being separated out.
I gotcha. Then right to remain silent. All right. Let's go ahead and talk about the spoliation potential instruction. The defense is requesting a tainted evidence instruction.
Yes, Judge. We believe that primarily applies to the car seat, lack thereof. There was a lot of testimony. There was admission by the police in this case that that they did say under oath on 2 occasions, as well as 4 years later, 3 years later, excuse me, in this courtroom, that there was a car seat, and it was included in the police report. And now, of course, the court is well aware we have not seen one, and they're saying that there isn't one. There's different versions of this instruction, Judge. This is the one that I put in. We wanted to change the language to missing. Obviously, that's fine with me too, but this is the one I thought best matched the facts in the case. It's frankly less confrontational in some sense. But so I chose a version and form that I thought would work better with the facts that we heard and the evidence in this case.
Ms. Jones-Brown.
Judge, the Commonwealth does object to this. The evidence, while it does show, I mean, the court's very well aware of what was testified to, and I think an inference or an argument on their part can be made to the record keeping of the police department or the procedures of the police department, or even if they want to shoot for the credibility of the lead detective, but there is no evidence that the backseat was recovered and then lost. So we would object to this.
Here's part of the problem. Part of the problem here is that I don't feel it was ever established whether a back seat ever existed. That's the problem I'm having, is that it is not as though we know, A, there definitely was this piece of evidence, and B, then it was lost. In fact, I think it's statutorily they're not, if it did exist, it potentially could be a violation of the law if it was destroyed or not kept, if it contained bodily fluid. KRS 524-140 talks about how if an item is found that contains biological markers such as bodily fluids, it is a violation of the law to dispose of it. The problem is I don't really feel like it was ever established that it did in fact exist.
I think the question to me, or it revolves around, the reason I submitted the instruction is I believe that the court and the jury are able to rely upon sworn testimony. And the officer in the case, Detective Tonelli, testified under oath at the preliminary hearing, and he testified that there was one. He testified under oath at the grand jury that there was one, and then in this courtroom 3 years later told Judge Cunningham that the biggest piece of evidence that they had to bring was the car seat. And actually, he may not have been under oath that third time, Judge.
And it doesn't matter. But here's the issue that I'm having, and I'm leaning towards allowing the instruction, but the issue that I'm having is that I just don't really feel like it was ever firmed up. You know, Tonelli's testimony was basically, yes, I said that, I was wrong. But I don't know. I really wish this had been a pretrial hearing, to be honest. But I don't feel like there was ever any testimony that it did, in fact, exist. Like, to me, Tonelli's testimony was more like, I thought we had the physical back seat, but we never did. But I don't feel like it was very clear, and frankly, I don't really think that the defendant should be penalized when it wasn't clear, and in fact, there are at least 3 instances of Tonelli saying that there is a back seat.
Well, Judge, at the PC hearing, he said, we believe the seat was located. We are waiting for our forensics analysis to make sure and confirm that. He qualified it. And that is what he believed up until he got the CSU report.
Which said,
Well, which listed the items taken from the dumpster and did not include a back seat.
and when was that?
Not until that fall.
Post grand jury
Post grand
presentation?
jury. Now, 3 years later, yes,
Yeah,
we
it's
were just
just-
sitting here and we were throwing out ideas. I mean, it was just like this.
I know, but you know, if you're the defendant and this detective is twice saying that there is a back seat, even though it's not listed in discovery, and then 3 years later he mentions bringing it into court, I think it was reasonable for them to rely on thinking there was a back seat too.
But then that was cured a week later when we came to court. And this was subject to extensive litigation under Judge Cunningham.
Oh, it was?
Yes.
Was there a missing evidence instruction argument in?
No, but I was accused of prosecutorial misconduct. I had to respond to a motion about this. It went on for quite a while.
I guess
The biggest problem I have is that I still don't really have any conclusive testimony about whether it ever did exist. You know, we had all these CSU people in here. Why not just have someone definitively say, no, we never had a back seat?
Judge, I feel like that was conclusively testified to because the defense asked it of almost every witness that testified. And it was not found in the dumpster. Now, I thought what the court was saying was, we don't know if it was ever in his car. And that is something that we don't, like, maybe it was taken out 3 years earlier. Maybe he
Right.
bought the car with no back
Right,
seat.
right.
But every police witness who testified, when asked, said that they recovered no back seats. And the person who would have recovered, what Detective Tonelli was testifying about at the PC hearing and the grand jury was the dumpster search. And Detective Peters and Rebecca Kimmer from CSU testified that no back seat was recovered in the dumpster, although they initially thought something might be a back seat.
What evidence rule is missing evidence covered by?
There's a Cooper's heading somewhere in there, Judge, about it. I understand the court's looking it up. Judge, just to respond, for what it's worth, I think this ambiguity is why it ended up as a jury.
I mean, that's kind of what I'm leaning towards is like, you know, the problem is it's been left pretty unclear, and I think that should lean towards the defendant. Let me look at this, 2.06. But there was not ever a spoliation or missing evidence instruction before now, right?
No.
Okay.
No, we had no argument on that point.
I'm going to allow the instruction. I do think that based on the evidence as it came out, and I'm looking at the case law in Beglin and coincidentally a case called Ordway, the Commonwealth. So it says the court held there is no special or unique threshold of proof involved, so long as the trial court is satisfied that a reasonable juror could believe from the evidence the substance of the first clause, the instruction is in order. And I do believe that the way that the proof came out, a reasonable juror could believe that the backseat existed at some point. So I'm going to allow that instruction. All right. And then we have the unanimous verdict instruction. They are substantially similar. In fact, I think that the Commonwealth is just a little bit longer, but they're pretty much the same. Does anybody have any position on whether it should say the verdict of the jury must be in writing, must unanimous, and must be signed by one of these a foreman, or actually foreperson, or the verdict of the jury must be unanimous in finding the defendant guilty or not guilty, and must be signed by one of you as foreperson? You may use the form provided at the end of instructions. Anybody have a position on that?
No, Judge. I mean, I'm not looking at Cooper's on it. I think whatever the,
Okay.
pretty close.
All right. Then we have our verdict forms. So these will be, as we discussed, for the first 3 counts of the indictment will be A, B, or C. And then the others will just be guilty or not guilty. So our jury, oh gosh, they're already back. Let me get these written up so you all can have about 5 minutes to review them, okay?
Yes, and Judge, we found some typos. Do you need us to communicate those, or do you already have those?
I don't think I already have them, but when I put this all together, we'll see if they're still there or not.
Okay.
Thanks. All right, you all can, this is going to take me about 10 minutes, so we'll take a 10-minute break. John, would you mind to let the jurors know it's going to be about another 10 minutes? Thanks.
All right, guys. So let's talk about what we heard here. So it looks like instruction-wise. Hold on one second. Apologize. I had a Bluetooth speaker hooked up in the back over there to the computer. Didn't realize it. But anyways, so what did we learn here? It looks like they're going to allow an instruction in regards to the missing back seat. In other words, the instruction is that they're going to allow that if the jury were to conclude that the back seat is missing, that they can infer that to say, hey, there could have been evidence that would have been favorable to the defendant, and they can view that in a light favorable to the defendant, basically saying that the fact that that's missing could have had evidence that could have been exculpatory to the defendant. In other words, could have been proof of innocence. And as a result, the fact that that back seat was missing has to be viewed in the most favorable light to the defendant. So it looks like the defense obviously isn't going to put on a case. It doesn't appear. I believe we're going to closing arguments next. And it appears that the defense's argument is going to be this. Hey, he was there. There's multiple people in the room. The only way you know who did what, in fact, you have evidence from people who took plea deals, very, very sweetheart plea deals, and they admitted to stabbing the victims in this case. They admitted to being present at every aspect of the case. In fact, one of the most significant ones, I think the one that they're going to struggle with the most is not going to be what happened in the apartment, but I think it's going to be the shooting in the street. Because I believe the fact that you have Ja'Cory saying, hey, it was my gun, I bought the gun, and he's out there and, hey, why does he hand it to Brice? It made no sense. He said there's money on someone's head. They have no idea what money was on anyone's head. There's no specifics. He just hands this gun that he's just paid $300 for over to Brice, and we're to believe for what reason? What to me makes more sense is he just bought this gun. They're out there driving around, bebopping around, and he is pointing the gun out the window at people, being stupid, being a 16-year-old kid. It goes off and shoots the guy. And then now they got a situation on their hands. Now they're worried. Now they're like, oh my God, we just, and then the Antoine, as you heard, or Anon, or I'm not sure how you say his name, rolls over the guy, right? Makes contact with him, bumps him. He's involved. So now you've got two cousins, right? They're involved. One of them's mistakenly shot a guy in the street for no reason at all. Because remember, this is a random person not associated with these guys. So to me, what makes sense and what I heard in this case is you have the guy that buys the gun, accidentally discharges it, kills the guy because he's running around being stupid. Guy gets shot. Now you've got the two kids that are out here talking smack in the street, telling their mother what happened. Now we don't know because they didn't call the mom. See, they didn't call the mom to come in and testify about what she heard from those boys. So we don't know what happened. So that would be interesting. What did the victim say? But what we know is then, and again, this is significant. This is why I think the defense actually has a much stronger case. Whether obviously I've put some videos up of how Brice acts and has acted in court, and he acts like a lunatic. But the bottom line is there's a huge difference between acting like a lunatic and being a jerk, and then actually being guilty of what they said he was guilty of. Because next, what do we have? We have again, remember, these witnesses are going to bring a little bit of truth and then they're going to sprinkle in what they need to get their deal. So what does Jacory say happens? He says, I believe it was Maurice, but I might be wrong on this. One of the two boys, I believe it was Maurice, comes at him with a knife. Now, he claims Brice, of course, who does not appear to me to be, he's not in any great physical shape, pot-bellied. Even then, you look at the interrogation video, you can tell this dude doesn't seem like he's got some sort of matrix moves that he's grabbing a knife out of anyone's hand. But allegedly, Brice, who's not involved in this, grabs a knife out of his hand and then gets an entire room of people to, for reasons we have no idea, to say, hey, you're going to be involved in this murder. We got to kill this guy. No, what I think happens is this shit gets out of control. They're there chilling, kicking it. Brice is the type of guy you already get the feeling that, again, in knowing the knowledge of the psychology of groups of young men coming together, they're not seeing each other's culpability. And in Brice's opinion, that's your business. Take care of it. These guys get in a fight. Maurice pulls a knife. A struggle ensues, and they kill Maurice. And now his brother's there. Now, you can't trust that the brother is going to take care of business, right? You can't trust that the brother is not going to tell about the death of his brother. At that particular point, the other groups put him in the bathroom. There's where the vote takes place. What do we do with the other brother now? Do we let him live and trust him? Or do we have to take care of him? Because we got, remember, Anwan now says, I got my cousin who just killed a man. He's killed 2 people now. He shot a guy in the street. Maurice and him get in a fight. Maurice pulls a knife on him because Maurice is all upset all over over what's happened. Now they decide we're going to go kill the man in the bathroom. Now, this is where, as a jury, in my opinion, if they all participated in that death to cover it up and decided as a pact of men to say, hey, listen, we all are knee deep in this stuff, man. We got to kill this guy. So they pull him out and they kill him. And that's when I believe you would say Brice gets involved, conclusively gets involved, and he decides, I'm going to go and dispose of the bodies, and I'll help you do that. And that's when he goes out. They put him in the stuff. They put him in the back of the car, and they do all the things covering this up. It does not make sense that Brice is just this murderous guy who's got money on somebody's head. That makes no sense whatsoever. So the problem you get is the third guy. The third guy is the problem that the defense is going to have in this story, I believe, if you look at all the evidence. And this is what I've taken from it, and I've watched this entire case. So I could see a not guilty on the first, a not guilty on one of the brothers, but a guilty on the third brother. Because I think the third brother was the one that they decided they had to kill him because of everything that happened with the previous 2. And then you've got the tampering with the body, which I think he'll get convicted of for certain. But I could see the jury saying, you know what, listen, we're going to acquit him of all 3 of these because maybe he wasn't involved. I mean, the only people saying he was involved, I think, are the 2 guys that actually did this stuff. And he might not even have been involved in killing anybody. Because I think what you're hearing is the real people that did the killings, I think they are those 2 brothers or 2 cousins. And they did this, and they did the things I think that you're hearing, or said, or at least decided that that's what should happen. So, anyways, that's where I think we stand. I think the jury's going to struggle with this case much more than many think. I could be wrong. But I think when you look at this case and you've got these 2 guys here, it'll be a matter of what the defense argues. Now, the defense, they put forth an opening statement that kind of was okay. They were like, there's a reasonable doubt, there's a reasonable doubt, there's a reasonable doubt, there's a reasonable doubt. But now we have the case in front of them. Now we have the story in front of them. So now it's going to be important for them to tell the story about why and what they believe the evidence shows or doesn't show. But to me, do we have proof beyond a reasonable doubt that Brice Rhodes was involved in this, in the murders? No. I believe the tampering, yes, with the corpse. I believe he helped dispose of the stuff. But I don't think you can trust or believe any of the witnesses. The police botched this investigation. So I think it's going to be a difficult case. Let's go back and see if trial is back here. All right, so trial is not back. All right, guys. So I figured while court's on break, we're going to do a little research here. I found an interesting video that we're going to watch. Let's see here if I can. This is his official YouTube channel. But this video here, let's watch this.
My name is Brice Rhodes. I'm currently incarcerated in Louisville, Kentucky at Metro Corrections. I've been awaiting trial for 4 years, and I still have no set trial date due to the prosecution's delays and excuses. Before I begin, I would like to say for the record, I am innocent.
So this is a video that was posted using jailhouse recordings where he makes a case for his innocence. Now, it does not appear he's going to testify in this case. So this is his testimony, so to speak. I'm surprised the state wouldn't have put this forward.
All charges. So I'm here today to expose and point out corruption and fabrications concerning my case. I believe it's important for the public and the courts to see this raw footage of corruption by detectives and the prosecution. What motivated me to promote this video is I seen how detectives in the Breonna Taylor case altered evidence and fabricated time frames, which is illegal. Her lawyers exposed this, so I shall do the same in my situation. So now, if you would, I would like you to watch and pay close attention. First, you will see at my preliminary hearing on June 3rd, 2016, a detective named Ryan Griffin, Ryan with an R, Ryan Griffin, state his name under oath and his testimony under oath. This shows how he committed perjury, first degree, which is a Class D felony in the state of Kentucky. Okay, watch.
If there are any witnesses in the courtroom who are intending to testify on
Ew, Daddy! Look at that!
Judge, on behalf of the Commonwealth, Mr. Rhodes also, case number 31 and 32, their motions to revoke, we will also get to the court to revoke.
Daddy, what do you
Started with all of this, would you please identify yourself for the record? Donnie Fuller, legal advisor on behalf of the defense.
Aaron Dyker, Sheila Seagull for Mr. Rhodes.
All right. If there are no other preliminary matters, then I would ask the county to call their first witness. I would like to call Detective Griffin. If you could please approach the witness stand here. Will you raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, and the defendant be perjury?
I do.
Be seated, and you may begin. Please introduce yourself to the board.
I'm Detective Brian Griffin with the Metro Police Department Homicide Unit. I've been employed with for the last 5 years. With LMP. I've been in homicide for the last 3 months.
And Detective Griffin, could you please detail for us the events that led to the defendant being charged with murder, or the events that occurred on May 4th of 2016?
Yes, ma'am. On May 4th of 2016, at approximately 1 o'clock in the morning, the victim in this case, Christopher Jones, was walking down the street when he was struck one time in the side. He was transported to University of Louisville Hospital where he succumbed to his injuries. As a result of the investigation of the other case that we are here.
All right, now I want you to think, guys, what I was just saying, right? And now we've heard all the evidence in the case. And if you follow the case, you should have heard all the evidence in the case. Understanding the evidence in the case as we now do, he was struck one time. Now, I'm not sure what the lies are that Brice is going to say that, you know, what this detective was lying about. But I'm just going to say that, you know, this is consistent. You know, what you're hearing here is exactly what I'm saying I think happened. These young kids come up with an idea, which you're going to hear. I assume he's going to float that story about, Brice thought there was a hit, and they make Brice sound like this really bad guy. That's not what happened here. I believe Jacory had the gun. He bought the gun. He's floating it around. He has no idea how to handle a gun. No idea how to handle a gun. And he's racking it and pointing it and Lord knows doing what. And they're driving around and he's pointing it out the window, I'm sure. And that's why you hear him say, "Get out the street." And bam, it goes off. One bullet. Not 10, not 12, not a shower. because if you're doing a drive-by, if there was an intent, you never know if one bullet's going to hit. So commonly you will hear in drive-by shootings, there's going to be a spray of bullets because they're trying to hit a target that's possibly moving or in a distance. One bullet, bam, it goes off, shocks the shit out of these kids. They drive forward. Now you've got Anwan who just stole a car, and he drives over the body. So now you have Anwan and Jacory are in this together, right? Now, Jacory says, oh, Anwan didn't want to go over there. No, Jacory wanted to go over to that house because I think Jacory heard that they were talking stuff. Brice may have told them that word was on the street that those two boys were talking about the crime. We did not hear from the mother or the grandmother or whatever it was that they said happened. We did not hear from that person. Of course, because I guess it was hearsay, so I guess they wouldn't have allowed it in the courtroom. But bottom line is they're talking. And we know because they admit to it, and we have to take that is the one consistent thing, that there's a confrontation between Jacory and, as I said, I believe it was Maurice is what the testimony had. It could have been the other brother. And that confrontation ensues that involves a knife. Now, what happens is Jacory says, okay, he removes himself from the moment of stabbing and says, no, Brice intervened, and then makes the decision to kill him and just makes it sound absolutely terrible, but it makes no sense. And then sometimes there's a vote, sometimes but there was a vote. There was one vote, I believe, in this case, because there was a confrontation between Jacory and his kid. They're kicking it, they're partying, they're having a good time. This thing happens. There's a confrontation. I hear you've been talking. What are you going to do about it? They get into a fight, and boom, 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 boom. He stabs him, and he's on the ground. Now, that's why it's on the carpet, right? Because allegedly, they're putting sheets down. So why is there blood on the carpet? There's blood on the carpet because the stabbing happened unexpectedly as part of a fight and a confrontation over the events that had happened 2 weeks before. Now you have the vote. Now they take possession of the other brother and put him in the bathroom and say, what are we going to do with him? Because there's no way he's going to keep his mouth shut that we just killed his brother. And that kid's in there scared to death, maybe with a sock in his mouth, and they're figuring it out. Now they're the gangsters. And then they pull him back out. Now the question is, can they prove Brice or whoever else was in the room? But I think the evidence is clear. Jacory and Anwan are the guys. And Anwan's helping him out because he's the younger cousin. Jacory is the one that I believe is the mastermind here. He's the one that's coming up with this stuff. He's the one that doesn't want to talk about it. He's the one that's like, I'm not going to say a word. Then they remind him, dude, you're going to go away for life. And then they try to say, oh, we're afraid. Oh, you're afraid? Everybody's afraid of this guy? He doesn't have a gun anymore because the gun's supposedly disposed of. So what are they afraid of? Anyways, let's get back to listening to this real quick.
Co-defendant that was with Mr. Rhodes the night of Christopher Jones' shooting stated that implicated himself in that shooting and stated that Mr. Rhodes was the shooter.
And so you said that he was struck in the side and that was fired in the shot.
Yes, ma'am.
And he died as a result of those injuries.
Yes, ma'am.
And then all of those, and did this take place in Ocean County?
Yes, ma'am.
And it was the defendant holding the bullet.
Yes, ma'am. Seated to my right and right. Yes, ma'am.
Did you respond to the scene on May 4th?
Yes, sir.
And where is that?
In the 800 block of South 44th Street.
Did you talk to any witnesses that evening around the scene?
I did not. That evening.
Did any other detectives talk to any witnesses that evening?
No, sir.
You said Mr. Jones was transported to, was it Bureau?
Yes, sir.
Were any detectives or yourself able to talk to Mr. Jones about the events?
No, sir.
And the four other officers canvassed the neighborhood and looked for witnesses?
Yes, sir.
Were you able, yourself or any other detective that you're aware of, were you able to talk to any witnesses who were able to provide any information about?
No, sir.
Would it be fair to state that the only person that you talked to that's been able to provide any information is the co-defendant?
Yes, sir.
How did you develop the co-defendant as a suspect?
The cook.
I think for the purposes of part of the clause, it is relevant. I'm going to ask you to answer the question, but it in fact, this witness is a juvenile, not to identify this person?
The co-defendant is juvenile, and it was developed as part of an ongoing investigation for another case, another homicide case that we were investigating.
And how did his name come up in that case?
He was brought in as a suspect, and he was being questioned with his involvement to another case. And in the course of that, he also implicated himself in this case.
Is it fair to say that took place on May the 24th or May the 22nd?
I believe so. I'm not positive.
Okay. If you're familiar with the other case, correct? Did you talk to the juvenile co-defendant?
I did.
Is it fair to state that before he was brought in the other case, that he was not a suspect in this case?
Prior to him being brought in.
But you didn't know at that point who was involved in the case that we're talking about right now. In your questioning of him regarding a separate case, he implicated himself in this case. When you say implicated himself, what did he say that implicated himself?
He was the driver.
He was the driver.
Correct.
And then, was this a drive-by?
No, it wasn't a drive-by as far as the cars never stopped moving.
Okay. Explain to me what the juvenile said he did with regards to this case.
The juvenile did in regard to this case?
Yeah.
He said that he was driving down the street. He was told to stop. Mr. Rhodes got out, fired a shot, striking the victim, and then they left.
Did the juvenile say whether he knew that this was going to take place?
He said that they were out looking for somebody, but I don't remember whether he knew that this was specifically going to take place.
Did he know who they were looking for?
I don't know.
Did he know why they were looking for someone? Did he give you any indication whether he knew the victim in this case?
To my knowledge, he did not know.
He said, he told you that he stopped the car, correct? And that Mr. Rhodes got out of the car? Where did he say that Mr. Rhodes went at that point?
He didn't go anywhere. He got out of the car and shot the victim.
Where was the victim struck?
While you were in the location, on the side.
Like on his abdomen?
Correct.
Do you know what type of weapon was used in that case?
No.
How do you know that?
There was a shell casing in front of us.
One shell casing? Where was that located? In the course of investigating this case, did you or any other detective talk to Mr. Rhodes?
No, I did not speak with Mr. Rhodes for this case.
Did anybody else speak to Mr. Rhodes?
No.
As far as you're aware, Mr. Rhodes has not been questioned regarding this case.
We could not question him.
During the course of your investigation, did you look for any video surveillance of that scene? I was trying to see what evidence they have behind Mr. Rhodes to the scene at the time other than the juvenile's statement.
I'm going to allow it for a limited purpose, but we're getting a little too far into this, so I think go ahead and answer the question.
I did canvass for video.
Were you able to find anything?
We were able to find video, but not of the incident itself.
Fair to say that there's no video of Mr. Rhodes committing this offense.
Detective Brian Griffin, 800 block South 41st Street. It's currently May 4th at 2 o'clock in the morning, starting a neighborhood canvass at 801 South 41st Street.
So I'm not sure what this is supposed to show. I guess it's supposed to show that he said he was Ryan Griffin and he says Brian, although the problem is Brian and Ryan are very, very close. So I'm not sure that proves anything. So I'm really not sure what Brice thinks this proves. But again, I think that I'm not sure why police get things so wrong, because they get tunnel vision after somebody. I mean, I understand Brice could have been charged with something in this, but I think they went after the wrong. I mean, well, I know why they did it. They went after the low-hanging fruit. These two young men, normally the guilty ones are the ones that are going to make a deal, and they start flipping on everybody else, and then they can get a bigger case. And a guy like Brice, who was known to law enforcement, who was a jerk, who was someone they didn't like. So I just don't know what this shows. This is very strange.
Second. Yeah.
I guess this is an audio of an interview he conducted that day, saying Ryan, and he puts B Griffin. I don't know. This really doesn't mean anything. But I understand now the reference to Breonna Taylor, because those detectives falsified evidence. These guys appear to have been falsifying evidence. I believe they got the wrong people to confess. I believe they've let the wrong people walk in this case. And I believe they went after and got tunnel vision on Brice, and now they're left with this, and we'll see what happens. We'll see if he gets convicted. But I think that he deserves to be convicted for something, but I don't think he deserves to be convicted for 2 of the 3 murders. Maybe not even 3 of the 3 murders, because it's not clear. You know, I'm making an assumption that he was involved in that, and since the only people we have to rely on are Jacory and Anwan, and they were the ones that more likely did this, and performed the killings, and decided, hey, this other one's got to die because we killed the other brother. We shot a guy in the street that they were witnesses to, so now we've killed him. It makes no sense that if Brice is killing witnesses to his own crimes,
talk to over here?
that he's
On the
going
other side of the street.
to leave everybody else alive in that room.
820 and 818.
Okay.
The first 3 have
It just makes no sense.
Supposed to. But 820, 818. No number on that house, and it jumps to 802. I have any idea what address this is. 3rd house from this 3rd house south from Dorhofer on the west side of the street.
I'm still trying to figure out. I'm listening to this. I cannot figure out what it is that Brice believes about whatever it is we're listening to proves anything about his innocence or about perjury. But we'll continue listening and see if we can figure it
How
out.
we doing?
Hanging out.
Yeah.
Other shooting, this shooting.
Yeah, you could stop with the shootings now.
Ain't up to me. Just not gonna make.
Now let me break down what you just saw. Basically, how can Detective Ryan Griffin state under oath that he responded to a shooting on 41st and did a neighborhood canvass when that was false? Because the official original police reports, such as the initial information response report and the Major Crimes Division investigation report, which is all the discovered, it never mentions Detective Ryan Griffin. His name is on no reports. His name is on no official documents. His name is not on no police reports. As you've seen the official original documents, such as the initial information response report, file number 16283, date 5/4/2016, it was submitted by Detective Brian A. Griffin, 7921. It states the lead detective is Brian A. Griffin. It's Brian with a B, Brian A. Griffin, badge number 7921. Detective Brian A. Griffin stated on Wednesday, May 4th, 2016, at approximately 0059 hours, Metro Safe Communications advised the homicide unit, LMPD 2nd Division, officers responded to a shooting near 804 South 41st Street. Detective Brian A. Griffin, 7921, also stated he arrived at approximately 0139 hours. Then he began a neighborhood canvass, and Detective A. Wilder assisted with the canvass. He stated he knocked on 801 41st Street, 803, 804, 802, and 800 homes and got no answer. This was all documented on the Louisville Metro Police Department Major Crimes Division investigation report. So it's clear that Detective Ryan, with an R, Ryan Griffin, committed perjury, first degree, by falsifying testimony under oath. Now, Detective Ryan Griffin also committed perjury second degree by falsifying written documents and discovery. He made a false fabricated recording of a neighborhood canvass. How can he have did the canvass when the official documents state that Brian A. Griffin and Detective A. Wilder did the canvass? He also had no body camera footage to show that he was even at the scene. Okay, the prosecution also committed perjury second degree by falsifying documents about evidence. The prosecution knew that the detective's testimony was inaccurate and false, and yet she still used this fabricated testimony and evidence to prosecute me. The prosecution's actions have been flagrant. This is called prosecutorial misconduct. There's no excuse for the prosecution's actions to be this flagrant. Not only did the prosecution and detectives break the law themselves, but they violated my constitutional and statutory rights. I have two questions for the public and for the courts. How many others have they fabricated evidence against? How many others innocent people do they have sitting in jail due to their fabrications? Okay, and why would a judge on my case allow this injustice to continue, this corruption to keep going on? This case calls for an immediate dismissal. The prosecution and detectives have clearly ignored their ethical obligations. Thank you.
Cursing at a judge, making threats, and fighting with your own attorney. It's exactly what you should not do in court.
WDRB's Stefan Johnson reveals why a notorious triple murder suspect has been doing it for years and keeps getting away with it.
Well, guys, Brice Rhodes was in court this week for a pretrial hearing.
Let's watch this.
He had a lot to
This should be
say.
fun.
In fact, maybe too much to say. Most of his threats and profanity were directed at officers of the court, but that's not who's complaining about his behavior.
They committed perjury in the court of law, which is a felony in the state of Kentucky.
If you missed it, Brice Rhodes' latest pretrial hearing was another wild ride.
Hey, sir, I just want to go back to the first thing about him being removed from my case.
In court, Rhodes was belligerent and confrontational, directing his anger at detectives, the prosecution, even his own attorney.
As far as him, he really doesn't have anything to do with this because we're not on speaking terms, and he's not in my best interest.
After being allowed a lot of leeway, Rhodes eventually directs his anger at Circuit Court Judge Charles Cunningham, who he's asking to dismiss the case and replace his attorney.
Your job is not to worry about me. Your job is to do your job. And his job, his job is to worry about. Your job is to do your job, not to worry about me. That's what I'm saying. Well, I worry about me.
And I said, he's up at cursing at the judge.
If Rhodes is angry about what happened in court this week, he's not the only one.
My first thought was to really just to go after him from the way he's been doing things.
Jackie Party is the grandmother of two of the three people Rhodes is accused of killing and was outraged by what she saw and heard in court.
It puts me in another state of mind because I can go in there. I done prayed. Lord knows I done prayed. When I go, before I even go to court, I pray to ask God to help me to maintain my composure because I don't know where this fool is coming off at.
And in every case, the family wants it to, they want immediate closure, obviously. And unfortunately, the court process takes a long time.
Elizabeth Jones Brown is prosecuting the case and understands the frustration, but says there's a reason Rhodes is being allowed to speak so freely.
We've explained to them that we have to do this right, otherwise we'll just be back there doing it again.
I'm going in there in a frame of mind, but when I see this nut.
Meanwhile, Jackie Party understands the process, but shares how she really feels.
He ain't doing nothing but playing the system.
Been 4 attorneys appointed to represent Brice Rhodes since he was arrested, and it's unlikely he'll get another one unless he's able to hire someone. So if there are no more issues, this case goes to trial on July 31st. I'm Stefan.
All right, guys. So that was a broadcast of a news clip. Now we're going to go in. Let's go and take a look at the testimony of one of the co-defendants, Jacory, and we're going to watch this until court begins. For whatever reason, court is delayed right now. We're not sure why it's delayed. They were supposed to be back soon, but I'm not sure what's happening here. So we will find out as soon as I have something to report. We'll get back to it. But for right now, I want to take a look at the co-defendant's testimony here. Let me see if I can find it. Let's see here. We're going to. This will be a.
I was in the back seat.
Here we go.
Back to the vehicle.
This is Brice.
What color was the car?
Blue Mazda.
And this is clips of Courtesy of Law and Crime. I want you to look at this here.
Who was next to Maurice in the front?
Larry.
Who was in the back?
Brice.
Were you behind Maurice or Larry?
I was behind Larry.
And the defendant was behind Maurice?
Mm-hmm.
So driver's side rear?
Yes, ma'am.
Why were you? Oh, was Anwar there?
Yes, ma'am.
Where was Anwar?
He was behind us in the truck.
What truck was he in?
He was in the truck he had that day. He was following us.
He followed you?
Yes, ma'am.
Do you know how he got the truck? Was it a truck that he had long term?
Nah, just for short term that day. Just for that day.
He showed up in the truck that day?
Yes, ma'am.
Okay. Why did y'all go to 41st Street?
Looking for somebody.
Who are you looking for?
I don't know.
Did you ever know specifically who you were looking for?
We never knew. We just went along with it.
Who knew? Who was the person who knew?
Brice.
Sorry.
Brice knew.
Did he tell you all who he was looking for?
No.
But did he tell you why he was looking for someone?
Somebody a price on their head or something like that.
Somebody with a price on their head. What does that mean?
Somebody with a price on their head, like looking for him.
Does that mean that somebody else is going to pay if this person gets killed?
It means the person who did it get paid.
The person who did it gets paid? Okay. How did you all know that there was somebody with a price on his head?
Brice told us about it.
Did he tell you all about this before that night or that night?
It was at night.
Did you? Okay, so you're all driving down 41st Street. You're in the back seat. Anwar following. What happens?
All right, so you just heard, again, I want you to assess this testimony. There's a price on a head. That's all he says. You can tell this guy's lying out in my opinion, he's lying out his teeth. He knows what happened. He shot that man on accident. He didn't hand the gun to Brice, but he knows Brice needs to have that gun in order for him to make sure he doesn't go to prison for the rest of his life. None of this makes any sense. This guy's saying, I buy a gun for $300. I've got the gun. And Brice says, hand it to me. And this scary guy, Brice, I hand him the gun. When I got the gun, I'm the scary guy in that moment. Come on now. And this guy, hell, you're seeing, I'm not sure how much they go into it in this clip, but you see where he actually forgets part of what he told the police. And of course, they're going back in their statement and reminding him. And he's met with his attorney. I mean, there's a lot of stuff that goes on before he ever gets to this point and starts telling the story that the state wants. Because the state put a provision in all of these witnesses' plea agreements that states if they don't tell a story that fits what they need, they can go back to a judge and have a judge assess the testimony, and the judge can then throw out the plea agreement post conviction of anybody else that they testify against, and then allow the state to proceed with charges against these men. And it'd be interesting to see what happens if Brice gets acquitted on anything or doesn't get convicted of everything they want him to get convicted of.
Rode around.
Here we go.
Maurice rode around. Stopped the car. And he seen somebody in the middle of the street. And Brice told him to get out the street. Shot him.
Who shot him?
Brice.
Brice Rhodes shot him. So you're in the passage.
And Brice told him to get out the street. Shot him.
Who shot him?
Brice.
Brice.
I played that back for a reason. Notice what happens here, right? Brice tells him get out of the street. He probably does. That's probably what happened. And what does he say there? What's it sound like he says? I shot him. Brice tells him get out of the street and I shot him. And I shot him. And the state jumps in there and says, who shot him? Brice. And then he starts crying because this is a moment that had an impact on his life. He killed a man in that moment. And then he killed a second man. And he's had to walk around and live with that. This is a guy that looks tormented. This is a guy who has a hell of a lot on his shoulders. And he's walking around with all that. And you can see he's tormented by it. He doesn't want to relive this. He doesn't want to talk about this again because of the fact that he did this. He's the one that did this. He's the one who messed up his life that day driving around. He bought a gun. He thought he was a gangster. And suddenly it went off and killed a man, an innocent man who had nothing to do with nothing.
Shot him.
Stopped the car. And he seen somebody in the middle of the street. And Brice told him to get out the street. Shot him.
Who shot him?
Brice.
Brice Rhodes shot him. So you're in the passenger side rear, right?
Mm-hmm.
So were you all, was the person who got shot on the other side of the street from you all?
He was on.
You don't know? It's probably an unclear question. Was the fellow on the sidewalk or in the street?
Street.
Okay. Was he crossing the street or what was he doing?
He may have been crossing the street. He was in the street, but he may have been crossing the street, but he was in the middle of the street.
Did Mr. Rhodes shoot him with a gun? I know that's obvious, but just to be clear, it was with a gun, correct?
Yes, ma'am.
What type of gun was it?
9mm.
How did he get the gun?
Got it from me.
Where did you get the gun?
Friend of mine.
How long have you had the gun?
I didn't have it a day.
You didn't have it a day? So you got it that day?
Yes, ma'am.
Why did you get the gun?
My own protection.
And how did Mr. Rhodes end up with it?
He was with me that night. He's with all of us at night. He told us that somebody had a price on their head, so he wanted the gun. So I gave him the gun.
That is ridiculous. So what he's asking us to believe is he gets a gun, he buys a gun, and I don't know if it's going to come after this part. I can't remember the complete order of things, or whether it was in defense cross when it comes out on how much he paid for it. But he buys this gun for protection and then gives it to Brice. What? Why? Why would you do that? And then Brice just randomly shoots somebody while they're walking through the street. That doesn't make a damn bit of sense. And perhaps there was money on the head. Perhaps they were running around. But this is a young kid. He's flossing. He's got his new gun. He's got his new toy. He's playing with it. And somebody said, get out the street. And I could see him right over there. Look, yeah, get out the street. And he goes to point the gun out, and bam, it goes off. Now, remember, you go, well, Brice was we don't know who was sitting where. We know Jacory says Brice was in that position. We don't have photographs. We don't have evidence of any kind as to who was sitting where or in what position.
Could you describe how he shot Mr. Jones?
He pulled up and he was in the street. I just remember that he shot him. I don't really remember. I just know he said, get out the street or something like that. And he shot him.
And were you sitting next to Brice Rhodes when he shot Mr. Jones?
Yes, ma'am.
Did you know Mr. Jones at all?
None of us did.
Had you ever seen him before?
Nah, I ain't never seen him dead in my life.
Did you ever find out if he, in fact, was the person with the price on his head?
Judge, we would object.
That's a statement. You want to approach?
No, I can rephrase. How did you feel about this situation?
I was young. I just went along with it, to be honest with you. We all did, you know what I'm saying? Kind of, we just...
I'm sorry, what was the last thing?
We just went along with
it. Did Mr. Rhodes, to your knowledge, did he ever show up with money from this price on the head business?
No, ma'am.
After the shooting, what did you all do?
So I want you to understand this. There's no money that ever comes up. Allegedly, we're to believe that this guy's going to sell the story. I just wanted the money. I just wanted the money, man. That's all I wanted. I wanted my money. Where was the evidence that there was any money? This is his equivalence. This guy is Charlie Adelson here, telling the story of a reverse extortion plot with the key missing ingredient. Where is the proof before you hand a gun off, before you go out in the street? Where's the proof that you're getting any money out of this? Where's the proof that any of this is happening? And don't sell me on the idea you was young, because you might have been young, but you were street smart. You were in the streets. You were doing this. You're not going to hand a gun that you just spent $300 on to another man and say, here, take the gun that I bought for protection. That doesn't make any sense. This guy's lying through his teeth.
We went to Maurice and Larry's house.
Did all 5 of you go or just some of you?
We all went.
Okay. What happened at their house?
We didn't really talk about much. We just basically just told us not to tell nobody. That was it that I remember.
Okay. Did you all discuss it later amongst yourselves?
Not really. I mean, to be honest, we ain't never seen nobody like get shot, you know what I mean? So I'm not gonna lie, we was all scared, you know what I mean? It wasn't just them two, we was all scared, you know what I'm saying? Maurice, Larry, all of us, we was scared, man.
You were scared?
Yeah, we was young. You know what I'm saying? We didn't really, we just went along with it.
How did you feel about this situation?
So now we're going to watch the second part where he's going to recount the stabbing part. Now, I want you to watch this. This is brutal testimony. You know, this is hard to hear. So I'm going to tell you it's graphic, but I want you to listen to what he doesn't talk about, the things he forgets about, and I want you to assess whether any of this makes sense that it would have happened the way he said it does. Because I think what does happen the way he says it does is he gets attacked. He gets attacked by one of the guys. There's a beef. He's the one that did this killing. These guys are talking about it. They're chilling. They're hanging out. They're kicking it. And the next thing you know, they get an altercation over it. Knife comes out. Stabbing happens. And now they have a decision. What do? They have a brother who's alive. These kids don't have any faith that they're going to ever, self-defense, no way. And they know they've already got another shooting that happened. And this is when the murder happened. The only murder happened is of the second brother that night. The first one may have been self-defense. It happened out of an altercation. These two guys are wrestling around. There's a knife, stabbing. Boom. He's bleeding out. Now what do?
I was young. I just went along with it, to be honest with you. We all did, you know what I'm saying?
I'm sorry, what was the last thing?
We just went along with it.
Did Mr. Rhodes, to your knowledge, did he ever show up with money from this price on the head business?
No, ma'am.
After the shooting, what did you all do?
We went to Maurice and Larry's house.
Did all 5 of you go or just some of you?
We all went.
Okay. What happened at their house?
We didn't really talk about much. We just basically just told us not to tell nobody. That was it that I remember.
Okay. Did you all discuss it later amongst yourselves?
Not really. I mean, to be honest, we ain't never seen nobody like get shot, you know what I mean? So I'm not gonna lie, we was all scared, you know what I mean? It wasn't just them two, we was all scared, you know what I'm saying? Maurice, Larry, all of us, we was scared, man.
You were scared?
Yeah, we was young, you know what I'm saying? We just went along with it.
Now, this is something that he says repeatedly. We just went along with it. We were all scared. Right. What he's saying is this begins with the discharge of a firearm that kills a man in the street. They all in it. They all going along with it. They separate. They're young. They're scared. Maurice and Larry start talking trash. Now you're going to hear start talking trash. They start talking about what occurred in the street that night, which involves this man right here that you're seeing on the witness stand. Now you're going to hear what happens when they all get together, and now Maurice ends up attacking him. I believe it's Maurice. We're going to find out here. And we're still waiting on court to resume, guys. As soon as it resumes, we will get back in the courtroom.
Did you all, any of you, discuss this prior to May 21st?
Yeah, me and Maurice did. And Larry. He told me he wasn't messing with Brice anymore because of the situation.
Did Brice Rhodes say anything?
No.
Okay. Did he say anything about Larry and Maurice?
Just said that he can't mess with them no more because they told their mama about the situation. He feared they would say something to the police.
So he believed they told their mother?
Yes, ma'am.
What does he mean that you can't mess with them?
No,
What did you, I know you don't know, but what did you understand?
Now, see, what he's saying here is Brice told him, so he's aware going into that day that these boys have been talking. So in his mind, you know, he's not sure what to do with it. He's young, right? And I don't know that he was planning to kill anybody or do anything, but he says, we can't mess with him. You need to stay clear of him. But he goes up and shows up at this party anyways. Confrontation ensues between him and Maurice, right? And it results in Maurice getting killed, and then the other people are going to hold him back. That's what I believe happens here. And like I said, just watch how this comes and ask yourself, does any of this make sense? Does any of it make sense whatsoever? That Brice just suddenly is able to get a gun away from him. He's the one with the handgun. He's the one with the weapons in his hand. Every weapon used is in this man's hand. And he's the one telling the story that it gets removed. Charlie Adelson has the money in his hand. He's handing it off. Now, once you admit the weapon's in your hand, once you admit the money's in your hand, and then you say, well, it was for this reason. Oh, he took it and he used it. He's admitted it, right? He owns this. The only difference in this case is Adelson was trying to get himself a not guilty verdict. This guy has got himself one hell of a sweetheart deal. He didn't want to tell that story. He didn't want to do this because he knows he's lying on Brice, and it bothers him. And he hates to even probably have to think about what this situation was because this thing ruined his life. He did 6-7 years in prison, and he still faces the possibility that they could go back and put him in prison if a judge finds that his story is incredible. Let's get back and listen to his testimony.
That to me.
Judge, we object to speculation.
I'm going to sustain that.
Okay. Did he tell you anything that he thought should happen?
He feared they would tell him, so he was saying we can't mess with them no more. We got get him back for telling him. That's I remember.
Get him back for telling?
Yes, ma'am.
Did he say anything more specific?
Not really, not that I remember.
Do you remember talking to Detective Tonelli about this?
Yes, ma'am.
Do you think if you saw a transcript of your conversation that might help refresh your memory?
Yes, ma'am.
I'm going to approach your honor.
You mind?
I'm going to show you page 10. That specifically.
Yes, ma'am.
Does that help refresh your memory? What did he tell you he wanted to do to them?
So we gotta kill him.
At that time, did you believe him?
Shocked. I mean, I didn't know what to believe, to be honest, because of the Chris situation. I didn't really know. I just I don't really know.
Where were you when he said this?
As I remember, it was just we was in the car one day. I don't remember what day. I don't remember what day. I just remember we was in the car and he was telling me this because Maurice was scared. You know what I'm saying? Like he was scared that he was gonna tell or whatever. So he was telling me that.
Judge, it's difficult for me to hear the answer, but I believe it's a mix of hearsay and non-hearsay. So we object to the hearsay part.
Sustain.
Let's move on to, well, in this time period, were there days when you saw Maurice and Larry?
Yeah, we were still with him every day after that.
Okay.
Me and Anwan was.
Were there days that you saw Brice Rhodes?
Yeah, at times, not often.
Okay. Tell us about May 21st, which I believe would have been that Saturday.
I remember riding around with my cousin, Q. Me and Emma was riding around with Q that day.
So Q is the nickname of your another cousin?
That's my cousin.
So Q and Anwan and you were in a car?
Yes, ma'am.
What were you all doing?
Just riding around, females. Q had a girlfriend. We were just riding around. I was calling Maurice and we was calling Larry because we was trying to go back to their house that day. And just kept calling and stuff like that because we usually we'll go out, we'll be out that day, and like at the time I really didn't have nowhere to go. You know what I'm saying? So.
Where were you living then?
House to house.
House to house?
Different friends' house.
What was going on with your? Did you typically live with your mom or your dad?
I had issues with my family.
Okay. So did you? How long had it? Well, when you were really little, did you live with your mom or your dad or both?
My mom, for the most part. My dad got killed.
At that time, were you living with your mom?
Yeah, I was living with my mom off and on. That's the reason why I was bouncing from house to house, because I didn't know where to stay at the time.
Okay. Okay, so you had a cousin Q who was driving you around that day with Anwan. Was he also Anwan's cousin, or was it the other side of the family?
Q didn't really look at him as a cousin, but you could say that because Antoine, which is Anwan's brother, is Q's cousin too. That's my mom's sister.
Okay.
So we was all cousins anyway.
So do Anwan and Antoine have different moms or dads?
They got different moms, same dad.
Okay. So Antoine was your all's cousin, and he was Anwan's brother. Mm-hmm. So you are related to Anwan through that? Mm-hmm. Okay, got it. So you're riding around with Q. What happens?
I was calling Reese, calling him back to back, trying to see. We was trying to go over there that night. Something that, as I remember, I said that Maurice actually he called me and let me know he was. I forget at the time. No, I'm sorry about that. Rephrase that. I called him to go over there, and we finally went over there. They was gone. Me and Butter went over. They was gone. And
so you went to the house where they lived with their mom?
Yes, ma'am.
Over by Iroquois Park?
Yes, ma'am.
And they were not there?
No.
Okay.
And I was confused because, he told me, after Maurice was telling me that he wasn't hanging with him no more, and fooling Brice no more, I was confused on why he was still with him and why they was still, with Brice after the situation with Chris. So I went there to spend the night, me and Butter did, and we got there, their cousin answered the door, and they wasn't there. They wasn't there that night. When we left, we kept calling phone. I called Brice's cell phone. I was like, "Where Maurice and Larry at?" And he said that they right here and stuff like that. And Maurice was in the background and Larry's in the background partying. There's people over there. I just thought everything was fine at that point. I didn't really think nothing, like, back when you asked me, like, was he serious? You know what I'm saying? Like, about doing that to them. I mean, at that point, I didn't think he was serious no more. You know what I'm saying? Like, I didn't really think nothing of it. I thought he was just going to let him live and we was all going to be cool. Stuff like that. I didn't really think he was really going to do that. I thought we were just going to party, so I insisted on going anyway, even though Q and Anwan told me not to go. I insisted because I ain't had nowhere to go. Q and Anwan really could have went to their family. Me, I just wanted somewhere to stay at night. I ain't really wasn't thinking about hurting nobody or nothing like that. We wasn't thinking like that. Anwan didn't want to go. My cousin didn't want me to go. but I insisted on going anyway.
So you went to get someplace to stay?
Yes, ma'am. So we went to Brice's apartment that night. My cousin Q dropped me off. He dropped me and one off.
Why didn't Q go?
Q didn't want me to go anyway. Q didn't really fool. He didn't really fool too much with Brice anyway. He didn't want me around him, so that's why he didn't really want me to go. And, we went that day. And, as I remember, it was people in the house. I believe a female and two guys, a female and a guy, as I remember. So and they was drinking. Everything was cool at that point. You know what I'm saying? Everybody was just in the house, you know, chilling. And I remember two other people being there, and I never seen them before. Mia, M1. Never seen them before.
Were Maurice and Larry there when you got there?
Yes, ma'am.
Okay. So it was Maurice, tell me if I get this right, Maurice, Larry, Brice Rhodes, a female, and two dudes you'd never seen before? Okay. And so at first everything's cool?
Yes, ma'am.
Okay. How long did everything stay cool?
Everything was cool until we was all drinking, and we was all just there, and I didn't know the other two people that was there, the two gentlemen was there. So I'm really confused at that point. I didn't really, we just partying, we kicking it, and then I remember that Brice said, he asked Maurice, "Are you telling on me?" or something like that. "Are you telling on me? Are you telling on me?" or something like that. Something like that. I just remember that part or something like that. He was asking questions and stuff like that. And Maurice had said something to me, and we was kind of arguing. We got into a dispute. And as I remember, that was before Brice had asked him, "Are you telling on me?" It had nothing to do about, you know, the situation. Me and Maurice just got into a dispute over the fact, like, we was all drinking, we was partying and stuff like that, and stuff kind of, you know what I'm saying? So he asked him, like, "Are you telling on me?" And he kind of denied it, like, "Nah, I ain't doing that," stuff like that. And at that point, he said we gotta violate him and stuff like that. I didn't understand. He just wanted, like, he just said violate him. And then, as I remember, before that, I just remember Maurice picked up a knife on me or whatever, and Brice had grabbed the knife from Maurice, and that's when he hit him. You know what I'm saying? He hit him.
So he hit who?
He hit Maurice.
And who is the one doing the hitting?
He hit Maurice because he picked up a knife on me.
But I'm sorry, just to be clear, who hit Maurice?
Brice.
Okay. Was the female still present at this point?
Female? Nah, everybody left. The female left because it was too many dudes there. As I recall, like, it was too many dudes at that point, so she left, and the other two people stayed, and Butter was there, and Maurice and Larry was there. But after that, he kind of, like, he didn't really go at me with the knife. He did, but he didn't. It was aggressive, so he hit him. Brice hit Maurice and made him put the knife. He grabbed the knife from him, and that's when he insisted on doing what he did.
Okay, so everything's cool. You and just tell me if I'm getting this timeline right. You and Maurice kind of get into a little argument.
Yes, ma'am.
I mean, did you think it was a serious argument?
Nah, we've been into it before, and next day we right back. Right back good. So I didn't think nothing of it. We didn't think to do it in that. No, it don't matter.
Okay.
To make it that serious to even, you know what I'm saying?
So when he pulled the knife, were you scared?
At that point, we all confused. You know what I'm saying?
No, I meant when Maurice pulled the knife.
I remember lunging, like,
Pardon?
I remember jumping back, like lunging back, like, you know what I'm saying?
And so at that point, Maurice pulls the knife. Mr. Rhodes takes the knife.
Yes, ma'am.
And when you said he hit him, was it a slap or a punch? Or what? Describe it however you remember it.
I don't remember. I know it was either slap or a punch. I just know he hit him, and he took the knife from him.
Where were you all in the apartment?
He was in the living room.
And was everybody standing, sitting?
So, we was standing at that point. Everybody was standing around.
Okay, so after the punch or hit, I'll say hit, is all this happening before or after he started talking about the violating?
I just know that he said we gotta violate him or something, violate them or violate him.
And is that after he hit him?
After he hit him, because
I'm just trying to get the timing. I'm sorry.
Yes, ma'am.
Okay, so he says, so is that like disciplining?
Yes, violate whatever he was planning on doing. Violate somebody.
When he said that, what happened next?
He said something about, he told me to, Brice had told me to, he said, I want you to, he said, I want you to violate him. I was scared. So, I'm like, what you mean? He said it. He's like, I want you to punch him in his chest. And if you hit him in his face, I'm gonna hit you. He told me it's Maurice. I just remember he had me punching him. He said, stop. Or something like that. And he had, I gotta tie him up. We gotta tie him up or something like that. As I remember. It's been a while, so I just remember certain detail like that. You know what I'm saying? That I can remember. But I just remember that he said we gotta tie him up. And tied him up and pinned him down. He stabbed Maurice, and
Who stabbed Maurice?
Brice did.
Okay. Was Maurice tied up at that point?
Yeah, he was tied up.
What was used to tie him up?
I don't really remember. I just remember that he was tied up.
Okay. Who did the tying?
Brice did. There's somebody else that was there. I don't really remember. I just know he was tied up and he had a sock in his mouth and he pinned him down and he began stabbing him. He made anyone stab him too.
Did you see where he was stabbing him?
Man, stomach, chest, stuff like that.
Do you know how many approximate times it was?
It was a lot. I don't really remember.
What was Maurice doing while this was going on?
What can you do?
Who was in the room while this was happening?
Yeah, it was me, brother, Brice, two other people, and Maurice. He's pretty much fighting, fighting, trying to, he made N1 stab him, and once N1 stabbed him, he kind of moved him to the door. He just had me standing there.
You were standing by the door?
Two other people that was in there, I didn't really know. They was already there when we got there, so I'm thinking that, you know what I'm saying? In my mind, I couldn't do nothing but stand there, worrying if somebody's gonna do something to us for, trying to interrupt anything. So he went to he kind of took Maurice to the door. I don't really remember who, but I just remember he going to the door, and Larry was in the bathroom. He made Larry come out, and the same thing happened to Larry. And once he did Larry, he made me stab Larry.
So I'm sorry to make you talk through this again, but I want to get the picture of where everybody is. While Maurice was being stabbed, where was Larry?
He's in the bathroom.
How did Larry get to the bathroom?
The other two people put him in there.
Did Larry want to go to the bathroom?
They made him.
Could you hear Larry in the bathroom?
I don't really remember. I just know he was in the bathroom until Larry come out next.
How did he pull him to the side?
Put him by the door.
Was Maurice walking? Or was he down on the ground?
He was down.
We noticed a couple typos on page 2. We thought that physical force and extreme emotional disturbance were being taken out.
Okay. Physical force?
Yes. And EED. None of the murder or manslaughter. Well, no.
Hang on one second. Okay.
The murder charges do not have complicity, although the manslaughter charges do.
So we're doing intentionally, wantonly, complicity in official proceeding, right?
Yes.
Okay. Got it.
So then, Judge, on page, for instance, 4 on the murder 1A, it does not have complicity in it.
Okay.
So that needs to be added. It is in 1B, and then that pattern follows for each of the murder charges. Complicity needs to be added to each of them.
Okay, so on 1B, 2B, and 3B?
1A, 2A, and 3A. It's in all of the manslaughter charges, but not in the murder charges.
Murder should be 1A, 2A, and 3A.
I'm sorry. The complicity language is not in the murder charges.
And it should be?
Yes.
And it should not, and it should also be in manslaughter?
Correct.
Okay. And that should be in 1A, 2A, and 3A.
Yes, ma'am.
Hang on, let me get that in. Okay.
So is it in, like, for instance, he acting alone or in complicity with others killed Christopher Jones by shooting him with a firearm?
No, it is. He killed Christopher Jones by himself or in complicity with others by shooting him with a, or by stabbing. Okay.
No objection. I noticed in 1B it says he killed Christopher Jones by himself or in complicity with others, and then it should say by shooting him with a firearm.
Yes, I changed all of those.
Okay. And then so for 2A murder and 3A murder, the same change with the complicity.
Yes, I've changed all of them.
The only other thing I noticed was that in the verdict forms, A, it says, we the jury find the defendant not guilty or murder instead of murder.
Okay.
That's all noticed by the Commonwealth.
We had a few other things we spotted.
Let me change that order of and the other ones as well. Okay.
Your Honor, on page 1, under unanimous verdict, I believe the court was going to change foreman to foreperson.
Yes, thank you.
And I'm not sure if that's the only location of that word, but I can
I'll double check it.
Yes, thank you. And then I believe the only other correction is a lettering on page 6. For example, on 2A, we have 2 B's. I think it's the Word document is just trying to.
Does that make sense, Judge? It says B for the, instead of A for the first option, it says B, and then it says B again.
Oh, I see it.
And then on page 8 for instruction 3A.
Hang on just one second. Let me get that formatting correct. Okay.
On page 8, under 3A, on instruction 3A, we have a C and a B, which should be changed to an A and a B.
Got it.
And then I believe page 12, instruction number 6, we have element A, B, and D. The last one should be a C.
Page 12, you said?
Page 12, yes.
No, that goes under B.
Okay.
That's the, because it's not a separate element. That's just the intentional portion. So it should be the same for 2A and 3A.
And then I believe the same lettering on page 15, 16, 17, and 18.
A instead of.
Be in our own list.
I see. Because it went to CD. I gotcha. Okay. Anything else?
Judge, we did do what you asked, and we discussed sort of the logic of today versus tomorrow. And I think that we concluded that it will not slow us down to do closings first thing tomorrow, as long as both sides are ready to go straight into penalty if that's necessary. And we can. We've already done penalty instruction.
I just hate to send them home, having been sitting here since 12:30. So we have to do instructions, and then you all think you'll be about an hour each. Is that right?
Yeah, probably less.
I think I'm just gonna push through. I'm gonna make copies. Janelle has left, so it's me making the copies. Please bear with me. The copies are still running. While they are, I think I'm going to bring the jury in, check with them to see if there's any issues with the admonition, tell them what's going on with Tonelli being gone, let you all rest, approach, we'll do DV arguments again, but then the copies should be done. You ready? I'm nothing if not a multitasker. We talked about it already.
I knew this was a different one.
Mm-hmm. Well, thank you. All right, good afternoon. Let me apologize. You know, we try so hard to make things go as scheduled, and sometimes it just doesn't happen. I can't tell you how much I hate it when you all are sitting there for that long. But I assure you we were doing the best that we could. Is there anything that anybody needs to report with regards to the admonition? Did everybody get their phones over here? Okay. We have one juror missing, as you can see. What we understand is he's fine. I don't want you all to be worried about him, but we have gone ahead and excused him for health reasons. Also, Detective Tonelli, you'll see, is not here. With his permission, he has asked that I convey to you that he had to go out of state. His mother was having surgery, and we told him, you know, go ahead and go. We are going to move into the next phase of the trial. When we left Friday, the state had rested their case Would the defense like to call any witnesses?
Your Honor, the defense rests.
All right. Would you all approach, please? Get the rest passed out to the jury in just a moment. You can have a seat. Thank you, Your Honor. You need something else? Well, don't forget to hit clear or it'll print 20 next time. Deputy Mills, there should be 14 copies of instructions.
I apologize, everybody. I had to take a phone call there, but I have been kind of watching out of the corner of my eye. So we are back. We have a little bit of a delay here versus...
Ladies and gentlemen, I am going to instruct you on the law of the case. That's what you're getting a copy of, is your instructions as jurors.
So it looks like they're going through instructions and then closings.
The thing that I must do is read through these all the way for all of you. After I have read the instructions, the attorneys will give closing arguments. Closing arguments, just like I told you in opening statements, are not evidence, but they are the lawyer's chance to talk to you about how they sum up the evidence and recommend how you should find after closing arguments. Now, after closings, you will retire to the jury room, where the first thing you're going to do is select a foreperson. That person will preside over your deliberations. It doesn't matter really who it is, as long as you all agree that that person will be the foreperson. The foreperson's copy of your instructions, it really doesn't matter, but you need to have like one official copy. So generally the foreperson's copy will be the copy that you sign. There's no reason for the foreperson to sign any more than one copy, and that will be the copy that you return to the court. If you go back for deliberations and you have a question, please write it out and then knock on the door. There will be a deputy stationed outside the door of the deliberation room at all times. So if you have a question, you are allowed to ask questions. You would write it out, knock on the door or open the door, let the deputy know you have a question, and hand the deputy the paper, and then we will discuss it in here, and I may or may not answer your question. The same thing for when you reach a verdict. Just let the sheriff stationed outside your door know that you have reached a verdict, and we will bring you back in as soon as possible. Now, during deliberations, you can only talk to each other. The deputy will keep your phones. I'll give you a break before that if you need to call anybody and let them know that you might be here a while. If during your deliberations you need to use your phone or you have some kind of an emergency, please advise the sheriff. They, as I said, will be posted outside the door at all times. They will come and tell me and see if it is okay for you to use your phone. There are restrooms also in the area where the deliberation room is, so you don't need to leave for that purpose. All right, at this point, I'm going to read the instructions to the jury. In the case of 16 CR 1891, Commonwealth versus Brice Rhodes, these are the jury instructions. Presumption of innocence. The law presumes a defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. You shall find the defendant, Brice Rhodes, not guilty, unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. Unanimous verdict. The verdict of the jury must be in writing, must be unanimous, and must be signed by one of you as foreperson. You should use the form provided at the end of these instructions in writing your verdict. Right to remain silent. A defendant is not compelled to testify, and the fact that the defendant, Brice Rhodes, did not testify in this case cannot be used as an inference of guilt and should not prejudice him in any way. Tainted evidence. If you believe from the evidence that there existed certain items that were potential evidence and that the agents or employees of the Commonwealth unintentionally tampered with them, you may but are not required to weigh this evidence in favor of the defense. Definitions. Intentionally. A person acts intentionally with respect to a result or to conduct when his conscious objective is to cause that result or engage in that conduct. Wantonly. A person acts wantonly with respect to a result or to a circumstance when he is aware and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of care that a reasonable person would observe in the same situation. Complicity means that a person is guilty of an offense committed by another person when, with the intention of promoting or facilitating the commission of the offense, he solicits, commands, or engages in a conspiracy with such other person to commit the offense, or aids, counsels, or attempts to aid such person in planning or committing the act. Official proceeding means a proceeding heard before any legislative, judicial, administrative, or other governmental agency or official authorized to hear evidence under oath. Instruction number 1A, murder as to Christopher Jones. You shall find the defendant, Brice Rhodes, guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 4th, 2016, and before the finding of the indictment herein, he killed Christopher Jones by himself or in complicity with others by shooting him with a firearm. And B, that in so doing he caused the death of Christopher Jones intentionally, or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death of Christopher Jones under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form number 1A. The verdict forms correspond with the instruction numbers. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction number 1B. If you find Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, proceed to instruction 2A. Instruction 1B, second-degree manslaughter as to Christopher Jones. If you do not find the defendant, Brice Rhodes, guilty under instruction number 1A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 4th, 2016, and before the finding of the indictment herein, he killed Christopher Jones by himself or in complicity with others by shooting him with a firearm. and B, that in so doing he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using verdict form 1B, then move on to instruction 2A. Instruction 2A, murder as to Maurice Gordon. You shall find the defendant Brice Rhodes guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22, 2016, and before the finding of the indictment herein, he killed Maurice Gordon by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he caused the death of Maurice Gordon intentionally, or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another, and thereby caused the death of Maurice Gordon under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form 2A. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction 2B. If you find Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, proceed to instruction 3A. Instruction 2B, second-degree manslaughter as to Maurice Gordon. If you do not find the defendant Brice Rhodes guilty under either instruction number 2A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22, 2016, and before the finding of the indictment herein, he killed Maurice Gordon by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using form 2B, then move on to instruction 3A. Instruction number 3A, murder as to Larry Ordway. You shall find the defendant Brice Rhodes guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22, 2016, and before the finding of the indictment herein, he killed Larry Ordway by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he caused the death of Larry Ordway intentionally, or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death of Larry Ordway under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form 3A. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction 3B. If you find Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, proceed to instruction 4. Instruction 3B, second-degree manslaughter as to Larry Ordway. If you do not find the defendant Brice Rhodes guilty under instruction 2A, that should be 3A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22, 2016, and before the finding of the indictment herein, he killed Larry Ordway by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using form 3B, then move on to instruction 4. Instruction 4, tampering with physical evidence. You will find the defendant Brice Rhodes guilty of tampering with physical evidence under this instruction if, and only if, you believe from the evidence beyond a reasonable doubt all of the following. A, that in Jefferson County, on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, destroyed, mutilated, concealed, removed, or altered items from 763 North Height, including a pink blanket, the knife, and or the backseat of the blue Mazda, and that in so doing he believes that an official proceeding may be pending or instituted against him, and he did so with the intent to impair the availability of the evidence at such a proceeding. Please indicate your verdict using Form 4, then move on to Instruction 5. Instruction 5, Abuse of a Corpse, Maurice Gordon. You will find the defendant Brice Rhodes guilty of abuse of a corpse under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following: that in Jefferson County, on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, placed the body of Maurice Gordon in a yard off an alley and attempted to burn it, and that he had no legal authority to do so, and that in so doing, he intentionally treated Maurice Gordon's body in a way that would outrage ordinary family sensibilities. Please indicate your verdict using verdict form 5, then move on to instruction 6. Instruction 6, abuse of a corpse, Larry Ordway. You will find the defendant Brice Rhodes guilty of abuse of a corpse under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. You'll see there's a typo where the word following is written twice on this one and the one before. That in Jefferson County, on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, placed the body of Larry Ordway in a yard off an alley and attempted to burn it, and that he had no legal authority to do so, and that in doing so, he intentionally treated Larry Ordway's body in a way that would outrage ordinary family sensibilities. Please indicate your verdict using Form 6. This is followed then, ladies and gentlemen, by a single verdict form for each instruction that I have just read to you. You will need to follow those instructions and, as I said, have the foreperson sign as appropriate in line with your verdicts. Now, we are going to have closing arguments. I expect that they will last until about 5:15 or so, maybe 5:30. Would anyone like to take 5 minutes to step outside and make any calls or anything that you might need to make? Because once we're done with that, you'll go straight into deliberations.
Will we be here for late tonight?
That's up to you all. It just depends, on how it goes. So, does anybody need to step out? All right, let's take 5 minutes. I'll have you come back at 3:35. Please remember the admonition's still in place. Am I okay? No. But I'm going to keep going until I am. Just overwhelmed.
All right, guys. So closing arguments have begun. Like I said, we're on a little bit of a time delay. So what's going on right now, if you're watching here, is. All right, guys. So closing arguments have begun. Like I said, we're on a little bit. Sorry, I had to close out a browser. The audio is cut for a few minutes. It is going to come back on. So I haven't watched. I always am watching. That's why I delayed a little bit, so I know what's going on with everything, with the stream, what's coming on. That way I can prepare the audience. Hold on one second. And it should be on here in just a moment. So this is a production issue on the court side here, unfortunately. Here it is. You saw the bailiff just go up and correct this.
Maybe the next day. Inevitably, the sun came out. When the sun came
And this is the defense doing their closing.
that appeared to be so strong, it looked like it would never collapse, never fall down. Every single time it did. Every time. The Commonwealth, in this case, bears a heavy burden. They admitted it in their opening. They bear the burden to prove to you every element beyond a reasonable doubt. And at times, they have seemed to have built the strongest, toughest fort that was going to last forever. I want to suggest to you that when you look at it and really think about it, it isn't so. Your job, and we talked a little bit about this when we were selecting the jury, it's not just one thing, it's multiple things. The most important thing that you do is you try to make sense from this witness stand of what really happened. You take the pieces of evidence that you have and you evaluate them. Decide which parts have credibility, which parts don't. And when you're thinking about their case and you're thinking about what they proved beyond a reasonable doubt, that's what you have to go from. The evidence that you actually heard from the witness stand. Because the other part of your job, and there's a reason there's 12 of you, right? Because you caught something and maybe you missed something. You caught something else, maybe you missed something else, and that's why you get to talk, right? You're not going to do separate analysis. You sit in a room together, and you have your notes. Some of you took a lot of notes, some of you took a little notes. That's up to you, right? That's your business. But you get to talk to each other, and you'll have the instructions from the court, and the instructions from the court are very important. That's why not only does the judge read them out loud, but each of you gets a copy. Those represent the actual law, the law that matters in this case. And then you get to do something that's sort of amazing, really. You get to apply the facts of this case to the law. That's part 2 of your job. You get to say, okay, now we've decided what happened. We've done the best we can to figure it out, right? And now we look and we say, did the prosecutor, did they meet their burden? Did they prove beyond a reasonable doubt? And then if they did, what did they prove? Because as the court read to you, there are multiple possible options. And then you're the ones who choose. Now, I'm going to talk to you for a little while, tell you what I saw, what I observed, what I think. The prosecutor's going to get up and do this exact same thing. Okay? What I say is not evidence. The prosecutor says it's not evidence. What you heard in the witness stand, that's the evidence. So let's talk about credibility for a second. You really heard two types of evidence in this case. You heard evidence, you heard a lot of evidence from either police or people who work with the police. And then you also heard evidence from the other suspects. I'm going to talk about those separately. So because I want to be clear. I want to try and be as clear as I possibly can. There were a lot of witnesses who either were police or worked with the police. And they told you little pieces, really. No, there's a little piece, sort of like a puzzle. Little piece here, little piece there. Sometimes they fit, sometimes they don't. The prosecutor's going to tell you that they all fit. It all makes sense. It's clear, crystal clear. It's not. You know them. You sat in this room. You heard the evidence from that witness stand. In their opening, the prosecutor talked about, I want to get this right because I wrote it down, a monstrous bloody scene. I think those are the exact words the prosecutor used. Monstrous bloody scene. What we heard from the witness stand, that was not true. What we heard from the witness stand is that there was an entire bunch of officers with a search warrant who can look at whatever they want that's on that search warrant, right? And went in the scene in Hyde Avenue, right, where we heard a lot of evidence. And they walked through and they didn't see much of anything. They walked through and they left. They took off and were gone for, though there was a little quibbling about it, it was about an hour and 45 minutes, something like that, before they decided they were coming back with a new search warrant, right? This was no monstrous bloody scene, blood everywhere, any of that sort of stuff. And we know that from the actual testimony we heard in the witness stand. But that's not what the prosecutors want you to think. They want you to picture it differently. I'm going to ask you to remember. Remember what the real evidence was from this real witness stand. We heard that the police weren't even able to videotape the scene. It sure would have been helpful for all of you. It would have been helpful to me. If there had been a videotape showing us what it really looked like that first time they went in, or the second time they went in. They said they had new evidence. They're going back 2 hours later, approximately. And on the third day of trial, we get handed a videotape. The missing videotape, which is completely, utterly black. Doesn't show that. That's not helpful. That doesn't help you. Doesn't help me. Doesn't help anyone understand anything. All right? It's important to remember what you actually saw, what we actually learned from the witness stand. You know, there was, right here, these photos that I tried so hard to find the other day. Found them in advance. You know, there was all the testimony. We saw it on the big screen. This dramatic, lighten up blue. And that's the drama. And you see it, and it has colors and lights. But the actual testimony is that none of this was blood. That's, I'm going to suggest to you, that's smoke and mirrors. I don't know what's showing you these photos where stuff lights up and then it turns out it's actually not evidence. That is not helpful. It's like anti-evidence. That is not something that is useful or helpful, and it definitely is not something that helps them prove anything beyond a reasonable doubt. It's the opposite. But it is concerning when people get on the stand and they talk about their degrees and they talk about how hard they worked and they did these things, and then they act like they found something when they really didn't. It's always weird when to stand up here and beat up on the police, right? Police do good things, they also do bad things. We know it. Right? We all know it. Anybody reads the newspaper knows it. They're not perfect, they're not completely imperfect. But the important part, the part that matters to us here, is what they did in this case, what they didn't do. I don't know, maybe it's normal to not do a report for 2 years. Try and do it from memory 2 years later, all this time later, try and get those facts, and then come into court and act like they know what happened. Maybe that's normal. Seems a little bit weird to me. But we know from this witness stand that that's the sort of thing that was happening in this case. That one officer said when he had to fix something in his report, he went and did an addendum and typed it all up and showed right up. That first detective who talked to us said it's impossible. Once it's down there, it just stays there. And that was his explanation for how he made a big mistake. How he said there were 6 shots when there was actually 1 shot. He said, I couldn't possibly go back in and fix it. It's been 7 years. Couldn't possibly do another report that explained something as important as 6 shots, 1 shot. I know that's not 6. I don't have 6 fingers. But what are some of the other things, some of the really big things, some of the very important things that were alluded to but not really explained from this witness stand? They told you, multiple witnesses, most recently Detective Tennant, but multiple witnesses told you that there were other adults at Hyde Avenue that night. Detective Tonelli said there was the dark-skinned man and the light-skinned man. There was also a Caucasian woman. I think they finally sort of agreed that the Caucasian woman had left before much happened, maybe, but she had been there. They're unable to figure out who this person was. It is confusing to me why, when they have Carter and Taylor, and we're going to talk a lot more about Carter and Taylor, why Carter and Taylor couldn't inform the police who this missing woman was. I would have liked to hear from her. I would like to know. I have investigators who work for me. If the police don't want to interview her, I want to interview her. I want to know what she has to say. Because I don't think that what we heard on the witness stand about Hyde Avenue is honest. I don't think it's correct. I don't think it's credible. I don't think it's true. But we don't get to hear that. But we also heard about the light-skinned man and the dark-skinned man. Now, Detective Tonelli said, well, we just never were able to figure out who the light-skinned man was. I can't invent somebody. Remember? It just happened, right? It's Friday. But he didn't say he didn't know who the dark-skinned man was. In fact, he told us who the dark-skinned man was. Why in the world was that man not on this witness stand? There's another eyewitness to all of this. And he knows who he is. And we never heard him. Never heard what he had to say. That doesn't make any sense to me at all. Just gone. The police were picking and choosing. The government was picking and choosing what they showed you in this courtroom. Now, the police had already decided who they wanted to charge. They already had their guy. And no matter what you think about the police, good, bad, or in the middle, when the police think they got their guy, that's what they do. And the problem is, sometimes they're right, but sometimes they're just wrong. But they are tenacious. I don't know Detective Tennellian. I'm not up here trying to say I do. Never met him before this trial started. He strikes me as someone who had made a decision and decided he was going to charge Brice Rhodes no matter what. And then he did. And then he is stuck to it no matter what. I want to suggest to you that that is not the way our legal system is supposed to work. The good news is that final 12, I know it's 14 of you now, who sit on this case act as a check to that. Because no matter what the police think for the last 7 years, no matter what they did for the last 7 years, no matter what the prosecution thinks, it's your verdict that counts. You know, when we're talking about things in this case that don't make sense, it's funny, I have kids. After a while, when your kids do or say the same goofball stuff, after a while it seems normal to you. My kids pronounce the words, I love you, a la boo. That's just how they pronounce it. After a while, it seems normal to me. I type it. It's like a made-up word, just for my family. Right? That's normal to me. That may sound like a strange thing to say, but what I want to explain is that the folks involved in this case have been hearing the same story over and over and over again, and after a while, it just starts to, it must make sense. I've heard it for 7 years. The death of Christopher Jones does not make any sense. I hope with your fresh sets of eyes and your ears, you heard that, and the first time you heard it, said, what? What? This doesn't make any sense at all. It's a fake or made up hit on someone where maybe the wrong person gets, it doesn't make any sense. This is not a plan. What kind of a plan is that? They couldn't make it make sense on the witness stand, and they tried a little bit. And then, when it wouldn't make sense, they just passed the buck. But you know what it does sound like? It sounds like the sort of story, sort of explanation that would get cooked up by two teenagers when they're trying to come up with some version that makes them look a little bit good. Or maybe I should say less bad. Doesn't make any sense. And when I say two teenagers, of course, I'm talking about Taylor and Carter, two cousins, two people who had an opportunity, time to come up with something, both before their arrest and then time after the arrest. I have to talk about this car seat. I don't even know what to say about the car seat. It's so bizarre, it stands out like a sore thumb. But when the prosecutor's trying to say, our police officers, had the highest level of integrity and honesty and professionalism, and you should take for granted all of the testing and all the evidence they collected, I want to suggest to you that the car seat really explains why you should not. We certainly don't have a car seat. We don't have one in this courtroom. You never saw one. I never saw one. But the police, under oath, said, we got a car seat. Said it a couple weeks later. Then a month after that, they were under oath again. And they said, we got the car seat. And they're writing, Detective Tonelli says, write this police report. After that, he's got the car seat. Now, I know he's saying there's a lot of evidence, it's hard work, can't know everything all the time. I hear that. But there's a few problems with it. One is that when somebody testifies under oath, like in this trial, to you, you have to be able to rely on it. That's why we have people testify under oath. They're supposed to get it right. It is their job to get it right. And if they don't get it right the first time, we certainly expect them to get it right the second time. If they don't get it right the second time, we don't expect them to put it in their police report, which gets sent to all of us, so we can do our job, so we can have the evidence, so we can explain everything as best we can to you. But that's not really the part that's a shocker. The part that's a shocker is 3 years later. You can have all the excuses about overwork and lots to do and everything, and I'm sorry I testified incorrectly under oath, and I'm sorry I testified incorrectly under oath again, and I'm sorry I put it in that report and I didn't fix it. But none of that holds water 3 years later. He said, I didn't realize until the fall of 2016. Okay. This is going to be up to you to decide how much slack you want to cut it. It is. It's not me. It's you. But I'll tell you this. 3 years later, in this courtroom, when he tells a judge, a different judge, but a judge in this case, we've had cases going so long, we haven't had changing judges. When he tells a judge in the courtroom, when we're having a whole big hearing, like you heard, on all the evidence, what's the biggest piece of evidence? He says, well, I guess it's going to be the big car seat that I bring up here. He told you under oath that he didn't realize what was really going on until the fall of 2016. How can that be correct when he's still saying we got the car seat in 2019? The prosecutor may get up here and say, everybody's overworked and sometimes people are sloppy. Sometimes the police are sloppy. If that's the case, what else was done sloppy? If sloppiness goes to the point of incorrect testimony under oath, how can we judge the credibility of the evidence that you have seen? It raises serious doubts about the credibility. judge even read an instruction that went to you about tainted evidence in this case. It's not just the defense attorney up here talking to himself talking. Right? That's the law from the judge in this case. But what I want to talk to you about, what I think the most important thing in this police investigation, part that literally woke me up last night thinking about it. It's not the car seat. It's not. They probably thought it'd be the car seat, but it's not. But you know what I really would like to know, and what I think all of you have a right to know? I want to know about that truck. That burned truck. That stolen truck. I want to know a lot about that truck. Where was that truck stolen? I want to know when it got burned. I want to know where it got burned. And most importantly, I want to know why it got burned. Because I'll tell you, there was an awful lot of mud thrown at Brice during this trial. But nobody ever tried to say he stole the truck, drove the truck, he burned the truck. You never heard those words from anybody. From anybody. Why in the world did that truck get burned? And why don't I know more about it? Why don't you know more about it? Why didn't we hear more about it? Why didn't the police seem to care about it? So what do we know? What do we know under oath from this witness chair? Well, we know that Carter said he stole it. We know that Carter and Taylor said that he stole it and drove it on the night of Christopher Jones' murder. But we also heard Carter say that he hit Jones with the truck. Now, the ME talked about blunt force injury. I don't know if that's from the truck or not. I have no idea. I know he had blunt force injury to his head. It might be, it might not be. I don't know. Prosecutor may have some opinions about that. They may not. I don't know. But he had an injury to his head. But what I do know is that Carter said he hit him with the truck. He said he hit him while he was down on the ground with the truck. He said he ran him over. The prosecutor asked him, I don't remember the exact question. He asked him something along the lines of, well, you know, by mistake. And he said, no, I hit him with the truck on purpose. That's the prosecutor's witness. That's the believable, credible person the prosecutor has put on this witness stand, is a guy who said he hit poor Mr. Jones while he's on the ground with a truck. For what reason? I don't know. I have no idea. I think the prosecutor didn't know he was going to say that. I certainly didn't know he was going to say that. We know that about the truck. Do you really want to know what I want to know about that truck? I want to know if Maurice Gordon or Larry Ordway's DNA were in that truck. Because you remember from what we heard from the witness stand, their DNA was not in the Mazda. There's so much talk about this Mazda, their DNA wasn't in the Mazda. But from what I heard, there's this truck being driven by someone who has confessed to being involved that is burned. We don't know why. We don't know when. And that never got tested. I want to suggest to you that maybe that truck is actually what was driving the two bodies of those young men around. Does that sound like idle speculation? I don't know that it is. Because why did he burn that truck? That night, there's all this talk about people trying to burn evidence, right? Was the truck burned the same night? The perfect and logical reason for burning the truck would be, in fact, that it had been used to transport the bodies of those two young men. Think about the story that Taylor and Carter told about how the bodies were removed from the house. I listened to it again. They're put in totes, those big blue bins. That's what they described. One of them said the sort of thing you put your Christmas ornaments in. If it's big enough to fit a person, it's not going to fit in the trunk of a Mazda. And we don't have a Mazda. I wish we did. You know, we could open the trunk, take out a tote, try and fit it in. But we don't have that. But use your common sense. If all of you have had a car, anything like that, those big totes don't fit. And they're certainly not going to fit two in the back. But you know what they fit in real easy? Back of a pickup truck. No problem. No problem. So you get to decide completely if all the things I just said don't matter. You get to decide. You're completely empowered to do so, right? But I'm going to suggest to you that they're worthy of discussion. They're worthy of discussion because the story you heard from Taylor and from Carter, I don't think is possible. It doesn't make sense. But the part that really bothers me is the lack of investigation and follow-up by the police of the truck. And I want to suggest to you that I believe it's because they had just decided who they wanted to charge. They decided and they were charging, and that's it. And since he's not associated with this truck, they're not investigating the truck. That's not the way it should work. It's not the way it should work. And it's not the way evidence is supposed to come into this courtroom so that it can be explained to you so that you can do your job. So let's talk for a second about Taylor and Carter's facility. They're cousins. It means they know each other, they're tight. They said they were. They said they were close. How can we evaluate their credibility? Well, one way is, do their stories change? Well, yes, we know they do. The police and prosecutors admit they do. They admitted that they did. There is no question that Carter and Taylor lied. The police are just saying that they liked the last version, but that one's not a lie. But there's no question that they lied. There's no question they changed their story. They admitted they did. The police admitted they did. The prosecutor admitted they did. They changed their story. And that's one of the things that we look at and think about when we're trying to figure out if someone is credible, if someone's being honest. Do they change their story? We know that specifically they lied. That's another thing we look at. Not just a changed version, but a full-blown admitted lie. They admitted on the stand that they had lied. They said they were telling the truth on the stand, but they admitted they had lied in the past. Now, Taylor said he was just trying to do the right thing. Just there trying to do the right thing. I want to suggest to you that that is nonsense. How do we know it's nonsense? We know it's nonsense because when he first came in here, he refused to say a thing. If he is so gung-ho to tell you that's why he's here, he's going to do the right thing and say the right thing, then why did he refuse to say anything while you sat here? You had to leave the courtroom. He's still on the witness stand after you came back. Remember what he said? I got nothing to say. I got nothing to say. I got nothing to say. He had to be threatened in order to answer questions. That is not somebody who's just in here trying to help, just in here to do the right thing. He's doing the opposite. What he admitted when I asked him was he actually didn't ever want to be in a courtroom like this. And he didn't ever want to tell anyone because he didn't think he was going to get caught. It's going to be up to you to judge the credibility of that witness. But I want to suggest that he's not credible. He's not. He came in and told you is not credible. And neither was Carter. Now, ironically, maybe you say, well, if Carter wasn't telling the truth, he wouldn't have admitted he hit some guy with a truck. I don't know what he was thinking in this courtroom. Incarcerated, he was the guy who had, came in incarcerated, right, testified. Think about some of the other just cold things that Carter said. Said he hit Mr. Jones on purpose with a truck, no reason. When he was holding a cell phone that he stole from somebody he helped kill, or maybe just killed, he got phone calls. He got phone calls from that young man's mother. And he kept the phone. And he just lied to her. So they're sleeping over. He actually said, when asked, I didn't care about her. It may not be an exact quote. That's what he said. He said, I think he might have said, I wasn't worried about her. That's the prosecutor's witness. These are the prosecutor's star witnesses. Confessed, admitted, actual murderers. Their final version is the best of the best. Their final version is, we participated in murders. That's the winner in the contest. They would have said anything the police wanted them to say in order to get out. And they both admitted that their testimony in this courtroom was so they could still have their deal. That's why they're here. But I want to highlight 4 things. Put them up here on this chart. Those 4 things I think are very important. I could have gone back through the versions they gave the police, the 126-page version, which is all nonsense. This is all basically jackknife. And then their later version, and the later version. But to be honest, at some point, I think it just gives everybody a headache. We have a headache already. But, so here's what I did. I went back through only what they said in this quote.
only what they said under oath in this courtroom to you, Carter and Taylor. I picked out 4 things. Why are they important? Because they both are claiming they're telling you the truth under oath. They say the opposite. So when you're judging their credibility, even if all you judge them from is what they said under oath to you in this courtroom, I'm going to tell you what those 4 things are. The first thing, I'm going to put Carter here. And Judge, if you need me to pivot this so you can see it.
It's okay, thank you.
Carter was the person who testified first. It's N1. Over here, I'm going to put Taylor. Mr. Taylor testified at the end of the day on Thursday. The first thing that they testified to you about under oath that they disagreed about, we just talked about, but I think it's worthy of the list. Carter said that he hit Mr. Jones with a truck. Taylor said, no, he didn't. He got asked, he said, no, that didn't happen. Jones with the truck. And the person who was driving the truck was Mr. We already talked about why I think that's important, because I think the truck's important. But let's talk about a different fact, and one that hopefully jumped out to you folks. The gun that was used, according to the testimony in this courtroom, to shoot Mr. Jones. Carter was asked point blank, where was that gun purchased? I can't ask you. I'm going to tell you what he said. What he said is, it was purchased in a trailer park. Said that under oath in this courtroom right there. And what Mr. Taylor said? Taylor said, I purchased it at the home of Larry and Maurice. Same gun, same day. Both prosecution witnesses under oath. There's no wiggle room there. One of those 2, I'm going to write it up there. Specifically, he said he purchased it from a relative, Larry Maurice. We don't know all the details of that purchase. But I was surprised when under oath the prosecution's second witness had a completely different version of those. Not some far-off 7-year-ago statement. Folks, we're talking about Tuesday and Thursday. No, Wednesday and Thursday. Those statements are made 24 hours apart. Somebody's lying. Somebody's lying to everybody in this courtroom, and most importantly, that means they're lying to you. Prosecutor may say this next one doesn't matter. I think it does. Remember all the testimony about the vote? I'm going to call it a vote. I'm going to quibble about the vote. It's people talking about whether or not someone is going to be pretty serious stuff. The kind of thing that you want to get right if you're testifying about the details. Carter said that he was the only one who said no. And he was asked specifically about Taylor. And he said, Taylor voted for death. Now, Taylor didn't even mention it when the prosecutors were asking the questions. He didn't even bring up the conversation. When I asked him about it, he didn't want to call it a vote. Don't call it a vote. I don't care what you want to label it. But he didn't want to talk about it at all. When push came to shove, he testified under oath that he voted for life. He said, no. They can't both be telling the truth. Carter said Taylor voted for death. Taylor self-servingly told you all he voted for life. Why do you think Mr. Taylor didn't want to tell you what really happened? Maybe it's because Maurice threatened him with a knife. Remember what Mr. Taylor told you about that knife? Mr. Taylor said the same knife he got threatened with by the victim was the one he held in his hand when he stabbed the victim. Same knife. Mr. Taylor have something to hide? Yes, he does. He admitted it. He was angry. Of all of the testimony, he's the one with an actual motive to do violence on that night. And the last, but very significant difference is about those Timberland boots. The boots. What did Carter tell you? Carter said Taylor stole boots off one of the victims. That's what he said. Taylor stole boots. But I bet you remember what Taylor said. And I bet you remember because I bugged him about it and asked him about 12 questions about it. That he said, I didn't steal any boots, those were mine. Taylor said they were his. He didn't steal anything. Those were his. You know the problem with that? No matter how much these guys put their heads together and came up with a story, they did 7 years ago. They did 7 years ago. Their story from 7 years ago is going to have pieces that they never talked about. And also, 7 years is a long time. We'll lose a few pieces here and there. Funny thing about the truth, you don't have to hold on to that quite the same way. You know, if somebody tells me a story and it's true, I'm going to expect that if they tell me that same story 5 years down the road, it's going to be pretty much the same. Now, that I might ask it different. They might tell it a little bit different, but it's not going to have these sorts of whoppers. And you know what else they didn't have the benefit of when they were putting their story together? They didn't have the forensics reports. Because when Mr. Taylor is saying, I didn't steal those, I own those are mine. Detective Vance told you that they belong to the victim, right? I asked Detective Vance, I said, Mr. Carter had an item that belonged to the victim. She had the phone. Detective Vance said, yes. I said, Detective Vance, Mr. Taylor had an item that belonged to the victims. He had these shoes. Detective Vance said, yes. Then I said, and Brice Rhodes didn't have anything that belonged to the victims. Detective Vance said, yeah, that's right. He didn't. But what else do we know about those boots? We know they were tested for DNA. They were tested in multiple spots. We heard the testimony from the DNA folks. And guess what? Mr. Taylor's DNA isn't on his own boots. Oops. It's on his boots. Stolen. Just like Detective Vance said. He's in here trying to look good. He's in here trying to protect himself and cover himself. And he doesn't want to tell you the truth. When you're evaluating the credibility of the witnesses that you heard from this witness stand, remember these things. Testimony under oath, spoken to you within 1 day. And it can't be true. They can't both be true. We already talked about Mr. Taylor and the knife. You know why they're in here. They're in here because of these. Now you'll have copies of these. These are yours, right? Everything that got marked as exhibits. It's mostly a lot of photographs, to be honest. And these are going to go back, and you can have them. You can look at them as much as you want, right? But I want to suggest to you that you really do look at them. Okay. Those two witnesses, the ones who confessed to being part of murders, 3, who we know lied. Nonetheless, this shows what they were looking at was up to life in prison on each murder, on each one, looking up to life. And what did they get? Because they're willing to come in here, they're willing to say what the police wanted them to say in this courtroom. It got reduced from life in prison for each murder to 5 years. 5 years. That's a pretty big drop. That's a pretty big motivation. Just to make sure that they stayed motivated. In this document, it says, even after you serve your time, and you're out, and you're done, you still have to come back to this courtroom, and you still have to testify under oath. And if we don't like it, we want to say that we don't think you told the truth. If we can convince a judge that you didn't tell the truth, then you're back at life imprisonment. Times 3. So you better do your job and get in here and say what you got to say. It's in black and white. So all of this, we're talking about credibility, all of this matters. Because you're going to have to decide whether or not the prosecutor really proved beyond a reasonable doubt their case. So I want to stop for a second. Why do we even have that? Why does that matter? Why is that the rule? We have that rule because there used to be a time that the police and the prosecutors could literally go out and grab somebody if they didn't like them. Grab them if they just thought that they were guilty. And then they were stuck. There are legal systems where you are presumed guilty and you have to prove you're innocent. That's horrible. In One of them is Iran. I don't ever want to get arrested in Iran. I have nothing against the country per se, but that legal system, I don't want anything to do with it. For a variety of reasons. Imagine how horrible it would be if the police got to say, I think you, I don't want to said, I think you did it. This is what we think. And from now on, you're in jail forever until you can prove you didn't do it. How horrible is that? We made a choice in this country, and we live by it, and we have excelled because of it. That the government doesn't just get to do whatever they want and charge whoever they want and arrest whoever they want. Because when they do, it may take 7 years, but finally they end up here. And they end up with you. You are here to make sure that it's not a guess. Beyond a reasonable doubt, it's not a maybe. It's not a probably. It's beyond a reasonable doubt. Now, I'm not going to try and tell you what a reasonable doubt is. I'm not going to try and define it. That's up to you to decide. But it's a big deal. It matters. Didn't matter, you wouldn't be here. I'm going to ask you to remember all the way back, and I said it once before, that there are two jobs. When you go back into that jury room, your first job is going to be to figure out the best you can what the prosecutor proved beyond a reasonable doubt. Then, and I'm not going to, the judge will read them all. I'm not going to read them at you. I'm not going to, you guys can all read them if you want to. Fine. But to apply the law and the instructions to what you believe the prosecutor proved beyond a reasonable doubt. And I'm not suggesting that's easy. Right? It may take a while. I don't know. It's going to be up to you. It's going to be up to how the four-person, frankly, runs the show back there a little bit. But I have complete faith that you have. I've watched. You're all paying attention, taking notes. I think that you will do both halves of the job back there. And I appreciate that you're going to do it. I'm going to ask you when you're doing that to remember the credibility of the folks who testified, and remember all the other things you know about the investigation. Things can't be, shouldn't be taken at face value. In the final analysis, the prosecution did not meet their burden. I think the police always assume, and government assumes, that if they can put on a big enough show, bring in enough people, that the jurors will just fall in line. Don't do that. You make your own decision, and I'm not going to tell you what it is. But you're more than just pawns for the police. You're the jurors in this case. And what you do matters. In the final analysis, the prosecution did not prove beyond a reasonable doubt the existence of an intentional murder that involves Brice Rhodes. It did not. Now, if you look at those instructions,
in there. It's a definition of wanton. It's a word that probably none of us ever use, but it's a word in our language, and the law likes it. So that's why it's there, and you get a definition of it. Try to make more sense out of it. That one's a little bit more wide open because it covers an awful lot more territory. Just because it's wide open and may seem more like the prosecutor met their burden there, does not mean they did. You will decide. And there are two different offenses that both require wanton rather than intentional. Again, that's all written down. The judge read it. You can look at it as long as you want. And hopefully it will make sense. There's 12 of you. That's how it doesn't make sense to one person, it makes sense to somebody else. But I'm going to ask you, let me go back into the room. Think about all the evidence you heard from this stand. Think about the lack of credibility of so much of that evidence. I'm going to ask you to return a verdict of not guilty.
Mr. Griffiths, thank you. Ms. Jones-Brown, would the state like to make a closing argument?
No. Sorry, I'm gonna have some squeaky noise. Ladies and gentlemen of the jury, it was Brice Rhodes who decided that Christopher Jones was going to die that night. It was Brice Rhodes who shot him. It was Brice Rhodes who decided that Larry and Maurice had to go. It was Brice Rhodes who stabbed them over and over and over. It was Brice Rhodes who gave the knife to Anwan Carter, to Ja'Cory Taylor, to Tyron Coleman, to the unknown man, to make sure they were all in it. He learned his lesson last time about people talking. It was Brice Rhodes who took those bodies to River Park and burned them. There are so many profoundly tragic parts of this case. I don't know which is the worst. There's Christopher Jones, father of 3, crossing the street in the West End. Nothing to do with any of this. Shot dead for the stupidest of reasons. Larry and Maurice, killed because they did what we would want any teen to do in this circumstance. Go to your mom. These 4 children, so desperate for adult male guidance that they keep hanging out with Brice Rhodes even after they became scared of him because of Christopher Jones's murder. There's Ja'Cory, who had nowhere else to go, sleeping in stairwells, going over there even when he didn't want to, because that was a place where he could spend the night. Maurice tied up with a sock in his mouth, bound, knowing his little brother's in the bathroom. There's Larry stuck in the bathroom, not knowing what's going on outside, we hope. And then Larry struggling when he comes out and sees the blood on the floor. Anwan Carter and Ja'Cory Taylor feeling they have no other option but to follow the orders of that man who forced them to participate in the murder of their best friends. Forced them to clean up after, forced them into this life that they now have. Arrest, prosecution, juvenile custody, adult custody, felony convictions, prison, having to come to court and testify. That is what this man has done to this entire group of children. Now, how do you know, based on the evidence presented here, that Brice Rhodes is guilty? A lot of it does have to do with the statements of Anwan Carter and Ja'Cory Taylor, but their statements were corroborated by other evidence in this case. So let's go over what we have. First of all, this case is charged in complicity, and you'll have this definition with you. It's on your jury instructions. But it means that you don't have to worry about who stabbed the fatal stab. If you believe that Brice Rhodes orchestrated this, if you believe that he was in on it, if you believe that he was commanding or soliciting or engaging in conspiracy with them, you don't have to worry about what stab wound killed them. He is guilty of the whole act. To return to how do we know he is guilty, we will start with the murder of Christopher Jones. Now, Anwan Carter told you he was following behind the blue Mazda. He knew that Rhodes was in the driver's seat, or the driver's side rear seat. He saw Rhodes shoot out the window and kill Mr. Jones. He admitted, Mr. Carter did, that he drove over Mr. Jones. And Dr. Lippincott told you that there was a wound on the head, a bruising that could be consistent. We don't know if that head bruising was caused by running over. But whether it was intentional or not, we know that Mr. Jones would not have been in that road lying prone to get run over by the pickup truck if Brice Rhodes hadn't just shot him. So again, complicity, he's in it. Now, Ja'Cory Taylor told you he was right next to Rhodes, inside the Mazda when Rhodes shot and killed Christopher Jones.
Stop the car. You see somebody in the street. And Brice told me the street. Shot him.
Who shot him? Brice Rhodes shot him. Ja'Cory Taylor told you he saw Brice Rhodes shoot him. Now, both of them described the Mazda in front, the pickup truck behind, and you saw on the Ring video that Detective Griffin found on the block that night, from that night, that there is a small car driving past, immediately followed by a pickup truck. And that tells you that they're not making this up. Ja'Cory and Anwan aren't making this up. Again, the shots that night, the one shot followed by 5. You heard that came in on the 911 call. Somebody said 1 shot followed by 5. Anwan Carter told you that after Brice Rhodes shot Christopher Jones, they drove down the block a little way and he fired off about 5 shots at a house. 1 shot followed by 5. Now, the defense pressured Detective Griffin on, why didn't you change the report when you only found 1 casing on the street? This is an example of why you don't change a report. Because it is a fact that the 911 call came in that way. Then later they talked to Anwan Carter. They find out why there are 5 shots following. And this goes to show that they're not making this story up. Anwan Carter was there that night. He wouldn't have known about the 1 shot followed by 5 that came in on the 911 call unless he was there. Now, this, he was in front. Ja'Cory was in front in the Mazda. I don't know if he turned around, saw what was happening. It makes total sense that he wouldn't have seen. He just saw Brice Rhodes kill a man. Makes total sense that he didn't turn around and see what Anwan Carter did with that car. So we know that they were there. I guess the defense wants you to believe that these kids just, took a Mazda and a pickup truck over there to commit this murder for no reason? That's what doesn't make sense. 15 years old, Larry was 14. So Larry 14, Anwan 15. Then you have Maurice 16, Ja'Cory 17. But these 4 teenagers drove over there. They were there because Brice Rhodes brought them there. And the rest of the story doesn't make sense except how they told it. Larry and Maurice started telling their mother Brice Rhodes was mad about it and he killed them for it. This crime had an effect on these kids, as Jacory told you.
You ain't never seen nobody like get shot. I'm not gonna lie, it was also it wasn't just him too, it was also all of us.
You were scared? The words and emotions of Jacory Taylor, now age 25, having been to prison, having lived 7.5 years since that day. It affected him. It affected Maurice and Larry. And the defense pointed out that when Jacory Taylor first came in here, he wouldn't testify. He started to, then he stopped. It took a while. As they said, he was threatened, but that was with contempt of court, the same thing any witness has to abide by. You come in here, you have to testify when you're under subpoena. He was here for what is possibly the scariest thing that happens to anyone, to come into a courtroom, to talk about what happened, tell about something that's horrific, public speaking. And he had to do it in front of the defendant and in front of the families of the victims. So it is no wonder that he was scared, that he was emotional, that it took him a while to get there. So they were scared. Larry and Maurice told their mom. What did he tell you he wanted to do to them? Brice Rhodes said, we got to kill him. And we'll talk about the instructions later on, but this is how you know it's an intentional murder. He told them they were going to go kill somebody with a price. It ended up being Christopher Jones. And look, we have no reason to think that Christopher Jones had a price on his head, and I'm not saying that the person who did have a price on his head, if that person exists, deserved to die either. No one deserved to die that night. But he told that there was a person with a price on their head, and that's why they were going down there to collect this money. You heard from Anwar and Jacory that the money was never distributed, so we don't have any proof whatsoever that Mr. Jones was anything but crossing the street. But that was Brice Rhodes' intent, to kill Christopher Jones, and this is his intent, to kill Larry and Maurice because they were telling. All right, now we come to Saturday, May 21st. Christopher Jensen told you that Rhodes borrowed his car that day, the Dodge Charger. Rhodes admitted in a statement that he probably was in front of Larry and Maurice's house in that car. Later, you have Jacory Taylor and Amon Carter riding around with Q. They stop by Maurice and Larry's. Boys aren't home. They eventually head over to Rhodes's. Q drops them off. Imagine how relieved Q is that he decided not to go in there that night. So Anwan and Jacory arrive. Everything's fine at first. People present are Rhodes, Larry, Maurice, Tieran Coleman, unknown male, unknown female. I have a few things to say about that while we're here. The unknown female and the unknown male have never been identified because Detective Tonelli has nothing to go on with their complexion and their gender. These were a 15-year-old and 17-year-old witnesses at the time. They went into a house. They weren't introduced enough that they retained names from this situation, if they were introduced at all. Hung out with these people. Female left. The other guy stayed, but they couldn't describe him any more than light-skinned male. So Detective Tonelli can certainly not go rounding up every white female and every light-skinned male in this county, nor do we want him to. He could not continue that investigation without more to go on. But Anwan Carter was able to give him more about Tyrone Coleman. At the time, he was describing him as a dark-skinned male and was able to point out a rap video, local rap video, that fellow had appeared in. So based on that, Detective Tonelli was able to build a photo pack, show Anwan Carter, he identified it, and then the investigation into Tyrone Coleman took off. So with enough information, of course, he continued the investigation. He would have liked to have done it with the other individual, but he did not have that extra clue as to what direction to take the investigation in. Now, Tyrone Coleman is obviously not here. You know that his case is being handled separately. If you believe the rest of this beyond a reasonable doubt, then that's one of those things I talked about in voir dire. Sometimes you do have questions. You're sitting there in the jury room, you might be like, well, I really would like to know why Tyrone Coleman wasn't there. If it's not A or B or C on the jury instructions, if it does not affect your reasonable doubt of those questions, set it aside. It's a question that you can ask afterwards, but do not let it affect you now if you believe everything else beyond a reasonable doubt. All right, to return to the events of that evening, we heard from both Anwan Carter and Jacory Taylor. Jacory and Maurice got into it. Maurice grabbed a knife. Jacory jumped back. Brice Rhodes took the knife from Maurice and hit Maurice. He then powwowed with everyone else. What Anwan Carter described as a vote and Jacory described as a conversation. Anwan remembers being the only one. Jacory remembers that he and Anwan did not want to do it. I don't know how he was phrasing things. I don't know what Anwan picked up from him. They are both telling about their memories here. I skipped over this one. Purchase in a trailer park. I don't remember that, but if you do, go with your memory. But obviously, as far as the events of that night with how this gun was purchased, as Jacory Taylor was the one who purchased the gun, we have a great memory of it. Anyway, votes for conversation, discussion. But what is important from that is that Brice Rhodes was still planning to kill them. He still had the intention that they die that night, but he wanted to make sure that everybody was involved. So he tied up Maurice, had Jacory punch him in the stomach as a violation, discipline, I guess. And then he began to stab Maurice over and over.
How many times did Brice Rhodes stab him? Where did he stab him? Was he standing up or was he on his knees?
He was on his knees.
And he stabbed him in the chest.
Chest, stomach. His chest, stomach. On his torso.
He stabbed him in other places. How long did this go on for?
He stopped breathing.
Until he stopped breathing. You saw the autopsy photos. You know that he was stabbed over and over. Larry was in the bathroom. Rhodes dumped Maurice by the door and had them bring Larry out. And he stabbed Larry over and over. And again, you've seen the autopsy photos. We'll have them back there. I don't want to show the courtroom, but we heard the testimony.
Did Do you know what happened to his brother? Was there blood in the spot that he was at? Did he respond to that?
Kick everything off. Get his hands intact. His hands free stuff.
Was his brother making any noise at that point?
He did.
So how many times did he get stabbed? Was stabbing?
He stabbed until he was dead.
Brice did.
He passed the knife on him.
Who did he pass the knife to? Why did he pass you the knife? They're both dead, right?
We all would be in it. So none of us do.
He said we're all going to be in it. He wanted it to be on all of them now. He had learned his lesson on people talking. Jacory's description was similar. Who's that Maurice? Was Maurice tied up at that point? What was used to tie him up? Okay, who did the tying? Where did you see where he was stabbing him? Do you know how many approximate times it was? What was Maurice doing while this was going on? Who was in the room while this was happening?
Brice, two other people. He's pretty much fighting, like trying to, he made that one stab. Once that one stab, he kind of moved to the door to have me stared at.
You were standing by the door?
Two other people that was in there, I didn't really know. They was already there when we got there, so I'm thinking that, you know what I'm saying? My man, I can't do nothing, stand there. Wondering if somebody's gonna do something else, I'm trying to interrupt anything, so he kind of took my wrist to the door. They all, I don't know what to do, but that's when he goes to the door. Larry was in the back. Larry come out the same day after Larry. Once he did Larry, he made me stab Larry.
Dr. Lippincott told you that the cause of death was multiple stab wounds. She said Larry had 21 stab wounds. You can see in Maurice's autopsy photos that he has 8 to his abdomen alone, other wounds to his back, other areas of his body. Dr. Lippincott told you the areas, abdomen, torso, pelvis, back, groin, genitals. Rhodes made Anwan and Jacory clean the house while he took the bodies over to River Park and set them on fire. He later drove the boys around to various dumpsters burning evidence. The knife was never found. We introduced photos of the knives that were collected to show you that police collected what they could find. We don't know, maybe those are the murder weapon. I don't think so. They don't match the description. They drove around different dumpsters that night, setting different dumpsters on fire. I would assume that's where the murder weapon is. As Detective Peters told you, there were approximately 7 reports of dumpster fires that day. And by the time 2 days later that he was checking, most of them had already been emptied. It's actually amazing that the pink blanket with Maurice's DNA on it was located. Anyway, that night, they noticed the back seat was bloody, so Rhodes tore it out and dumped it behind someone's garage, as Ann Carter told you. Before I turn the page here, whether Taylor stole the boots, he said that he and Maurice both had those boots, that they started out as his, he lent them to Maurice. He didn't remember how the boots got there that night. He took the boots at the end of the night, though, and they had blood on them. This was just all part of the investigation. Now, yes, their stories are inconsistent on these points. I think there's an explanation for each one, but I also think this shows you that these stories were not concocted. They didn't sit there and memorize each other's statements. They came in here and told you about something they remember from 7 years ago. And these are all minor points, sorts of things that would become fuzzy after 7 years. The things they did say, the things they do remember, that Rhodes tied up Maurice, that Rhodes stabbed Maurice, that Rhodes made them participate, that Larry was stuck in the bathroom, that Rhodes tied up Larry. Those are the things they remember because that's what you would remember from all of this. All right, we've heard a lot about the police investigation over the past week, so I'm just going to summarize because I know that you all took in all this information, witness after witness. The response to River Park, the lack of any identifying information on the victims, how the police were trying to figure out who they were. It was not until Olmsted Academy contacted police and they realized that it was Maurice and Larry that the case moved forward. Detective Tonelli went to Elizabeth Wren's house, spoke to her brother TJ. TJ Wren led Sergeant Vance to Brice Rhodes' address on Haight Avenue. Vance saw Rhodes go into and out of the apartment and then followed him until they could take him into custody. In the defendant's interview, he admitted knowing the boys. You might have noticed, though, that he chatted with the detectives for quite a while. They were phrasing it as a missing persons conversation. Chatted with them for a while before he said, "Oh yeah, TJ told me they were dead." Which would be a little odd if he weren't involved with this. He admitted he was probably in front of their house in the Charger the last day they were seen. And yes, Detective Tonelli said that was on video, and it wasn't on video. But that's a police investigative technique. Police don't walk into an interview room and say, "Excuse me, have you participated in 1 to 3 murders lately?" No? Okay, well, thanks for your time. They have to use techniques to get people talking, and that was one that they were attempting. And he did admit to being there, probably. Okay, meanwhile, while this is going on, detectives are over on Haight serving a search warrant. And no, there was no bloody scene when they walked in. Why? Because the boys spent all night cleaning it up at the direction of Brice Rhodes. They collect the knives because they know that this is a stabbing case, possible murder weapon. Meanwhile, you have Sergeant Vance and the marshals pinging Maurice's phone, finding it with Ann Carter, who was so young and naive that he didn't know that police could track a cell phone. Ann Carter was interviewed. And he didn't change his story multiple times, he changed it once. In the beginning, he told them that he didn't know what happened. Then his mother and sister arrived. He spoke to them. He asked to speak to the police again. And that is when he changed his story. That is when he told police about his involvement and the involvement of Brice Rhodes in this case. Months later, he repeated it at a proffer at the time of his plea, and in court, he repeated it to you. But it's important to note that he was already saying this long before the prosecution of the case and any sort of plea negotiations had started. He admitted his involvement, and he talked about doing anything he did at the direction of Brice Rhodes. He talked about Brice Rhodes wanting to kill Maurice and Larry and killing Maurice and Larry, wanting to kill Christopher Jones and killing Christopher Jones that night that he was picked up, May 24th. Thus the second search warrant, because now police knew where the murder happened. And you saw the pictures of the carpet being pulled up. This is not something police are going to do willy-nilly at everyone's apartment that's involved in a crime. They needed a second search warrant because now they knew that this was a murder scene. And so now they had enough probable cause to go in and rip carpet up. And yes, the video was dark that you heard from Rebecca Kimmer. They tried to get it on video. It was dark. That's why they turned to the next step, which was just taking the carpet itself and testing that for blood. The police also interviewed the person who had rented the car that Rhodes was driving that day, who happened to be his neighbor, who was able to direct police to the blue Mazda with no backseat, reeking of bleach. Both cars were processed. Other people were interviewed, some of them with no further information. There was a child at Olmsted who was interviewed, Brice Rhodes' mother, cousin Q. The next stage, Corey Taylor was arrested and interviewed. Detective Peters and Metzler were finishing up the dumpster search, and later Sergeant Vance collected the boots. So what do we know from all of this? From the second search warrant, we know that the carpet was covered in blood, as was the carpet padding. And we know, because Stephen Barrett, the analyst from the lab, told you, the blood matched Larry at an estimated frequency in the nonillions, which is far higher than the billions of people that are on the earth today. So there's a 1 in nonillion chance that that wasn't Larry's DNA. So they took various cuttings from the carpet. On one of them, exhibit 24-1, it was Larry plus one other person. On the other one, it was Larry. From the carpet padding, same thing, Larry and one other person. The DNA for the other person was too limited to make a determination. But this makes sense, as Larry was the second person to bleed out on the carpet. What else do we know about from the apartment? Thought that was interesting. I'm not saying that everybody that bought White Castle that weekend was involved in this, but I do think that's interesting. All right, we know that these sheets were off some of the beds, pillowcases off the beds, and we know that a lot of bedding was found in that dumpster, burnt and bloody. What do we know from the dumpster search? We know that Detective Peters, Detective Metzler were faced with a dumpster full of trash. We know that the reason they were looking in dumpsters at all was because the back seat was missing. They wouldn't have gone out just to search for one pink blanket. But fortunately, that's what they found. But we'll get there in a second. So they come to this dumpster, it's full of trash. They call in and say, found it, thinking that some of this was going to be the backseat material. And that's what Detective Tonelli was left with. This search, you heard, took hours. It took well past midnight. He'd been told, they found the back seat, and they did not come back to him at the end of this and say, we found a lot of bloody sheets and blankets and towels, but we didn't find the back seat. He just did not get that information. So when he went to testify, he testified in the probable cause hearing that he believed they had found the back seat. He qualified it. He said, further testing, we're awaiting further testing, but we believe we have the back seat, because that's what he believed at that time. And it was not until he started getting all the reports, and really, He's got other cases going on. I mean, we all wish that we were all straight on the back seat from the very first moment. But yes, he's got other cases going on. We were sitting here. The judge said, what's the biggest thing you've got to bring in? He's speaking from memory about reports that he looks at from time to time, but didn't study up on before every court appearance, and he said probably the back seat. If he could find the back seat, he would have brought it to you. He would have tested it, but that back seat was never found. And we know what happened to the back seat, something that police only found out about later at a subsequent interview when Detective Tonelli did say to Anwan what happened to the back seat. And Anwan told him and tried to show him on his phone, tried to show him where the garage was, but only knew the neighborhood, didn't know the exact location. All right, so we have the dumpster. We have the pink blanket found in the dumpster. As Stephen Barrett told you, from the pink blanket, in 2 different spots, Maurice's blood was recovered. Now, while we are on the subject of the labs, what else do we know? The tire tracks from the scene were compared to the Mazda tires. Scott Doyle told you it's really difficult to get a comparison on tires, and in fact, in this case, he was not able to identify or eliminate the Mazda. The shoe prints, he was able to eliminate those shoes from the shoes that Brice Rhodes was arrested in. But we don't know what shoes he was wearing that night. I wouldn't be shocked if they weren't burned in that dumpster or a different dumpster. From the Mazda, swabs were taken from the driver's seat back near the headrest. They were presumptively positive for blood, and Stephen Barrett was able to find a partial DNA profile, mixture of at least 2 individuals. Due to the limited nature, no meaningful comparison could be made. So blood was found in the Mazda. It was not found on the parts near the where the back seat would have been, either because that area was bleached. 2 different detectives told you the car smelled heavily of bleach, and the analyst told you that bleach can degrade a sample, or because the blood was on the back seat that got ripped off. Anwan told you that that seat was covered in blood, and that's why Brice Rhodes decided it had to go. That's where the blood was in the car. And the reason that it is not here in these lab reports for analysts to tell you about it is because Brice Rhodes got rid of it. Now, Brice Rhodes' DNA was not found anywhere but on the gear shift or the steering wheel. That's true. But you know who else's DNA is not anywhere on these lab reports? Anwan Carter and Ja'Cory Taylor. The reason that Rhodes' DNA, Ja'Cory's DNA, Anwan's DNA is not all over the place is because they are not the ones who are bleeding out on all these pieces of evidence. It is Larry and Maurice who are bleeding on the evidence, and it is their DNA who is found. If they want to say that because Rhodes' DNA is not on anything, he wasn't involved in this, the same would hold true for Ja'Cory Taylor and Anwan Carter. Their DNA is not on it either. We know they were involved in it because they told you. So the same logic does not exonerate him from that analysis. The DNA in Rhodes' apartment, the DNA on the blanket in the dumpster, the ripped out back seat, these all corroborate what Anwan Carter and Ja'Cory Taylor told you. Obviously, the defense does not want you to trust them. They asked in opening, why are Taylor and Carter still alive? Well, 1, they weren't the people who told their mother. 2, he had learned his lesson and made them get involved in the second one. And 3, police put an end to this before anything could happen in future. We don't know what would have happened 2 weeks later. Carter told the truth 2 days after the murder, after initially not, but then talking to his mother and sister. Do you think that his mother and sister came in there and said, I've got an idea, why don't you tell them that you're involved? Why don't you tell them that you stabbed them too? That's a great idea. No, they went in there and said, tell the truth. If this were not the truth, he would have said, I was just an eyewitness. I just saw it happen. I didn't do anything. The fact that Carter gave them so much information that led to his own conviction for facilitation to murder corroborates his statement. Jacory, the next day, May 25th, said he didn't know anything about it. I'm sorry, there's the Mazda.
What do you all notice about the car?
Hold on. Why didn't you and Anwan just leave during the night?
So
Why didn't you? While he was gone. So 2 days after this whole situation, he's forced to participate in the murder, scared, not leaving. 2 days later, he's in an interview room, alone, no father, no mother, no one to talk to, knowing that the last people who told what had happened had ended up stabbed multiple times. So he told police he didn't know what happened. It was not until later, when he had been in custody, ironically safe from this whole situation, until he had an attorney, until he had time to think about this, that he came forward. I'm going to return to the slide that I had skipped. This is back to the back seat. I just wanted to play this for you in case you missed it. Oops.
what do you all notice about the car?
The back seat.
And so, how was that handled?
Cut the back seat out.
And who cut the back seat out? What did he do with the back seat after he cut it out?
Put it in the back of somebody's garage.
So that's why we don't have the back seat. Okay, hold on. I'll get to this in 1 second. But first I wanted to say, if you don't like the plea deals I did with these co-defendants, that's fine. I mean, that's my signature right there. You can write on the back of your jury forms, I think they got too much time. I don't think they got enough time. I don't think you should have amended down. Well, I don't know how you feel about this. So you can call me up later, look up my office's number, call my office. But if you believe what they told you, if you believe that he's guilty beyond a reasonable doubt, then your feelings about this plea deal don't affect your verdict. I had to make a decision on what to do with Jacory Taylor and Anwan Carter. And one of the things that I knew was important was getting you all the evidence that you heard in this courtroom. And these are the sorts of things, sorts of decisions that we have to make in courtrooms all the time. Because the witnesses to crimes are often also the participants in crimes. So if you are mad at what I did, that is fine, let me know. But that doesn't mean that Brice Rhodes is not guilty of murder. And so let us talk about what you need to find under the instructions. So it's actually very logical. You go through page by page. You start with 1A, and then the language for murder and the language for manslaughter second is the same for each victim. I just picked Maurice here because he's the one in the middle. And what's in parentheses is the things that change from instruction to instruction. So for Christopher Jones's murder, it says the 4th day of May, 2016, and shooting him with a gun. Obviously for Larry's, instead of Maurice, it says Larry, but the date and the manner are the same. But, so for each count of murder, your analysis is the same. You shall find the defendant guilty if you believe beyond a reasonable doubt that in Jefferson County, the instructions actually say in this county, but it's obviously Jefferson County, you saw the map. On or about the dates in question, that he killed each victim by himself or in complicity with others, and we've gone over all that, by shooting Christopher Jones, by stabbing Maurice and Larry, and that in so doing, he caused the death of each of them intentionally. And there's going to be an or that I'll flip to in just a second, or wantonly. You know it was intentional because he planned it, he premeditated it, he told the witnesses in advance that he was going to do it, and then he did it. But let's go to the or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death under circumstances manifesting extreme indifference to human life. So I'm going to flip up to the definition of intentional and wanton. Intentional is what you think it is, when the objective is to cause that result, in this case being death. Wantonly is when someone is aware of and consciously disregards a risk, a substantial and unjustifiable risk, that the result will occur. And the risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct, standard of care that a reasonable person. So if you believe that he's driving down the road, shooting his gun, not specifically intending to hit and kill Christopher Jones.
Sorry, can you all approach for just a moment?
Sorry, to make it clear, I'm giving you an example of how this could be a wanton murder. I'm not saying this is the only way it could be a wanton murder. So for an example, because wantonly means that somebody is aware of, okay, first of all, wantonly is not intentional. So that's what I'm saying. It's like we've moved past you. This is only in the circumstance where you all think it's not intentional. So it would be wanton if you believe he's aware of and consciously disregards a risk. So he's aware that shooting somebody is dangerous. He consciously disregards the risk that shooting out the window he could hit a passerby. And that the risk of him hitting a passerby is of such nature and degree that disregard thereof constitutes a gross deviation from what a reasonable person would do. So if you think a reasonable person would know, I shouldn't shoot out the window because I might hit somebody, and that disregarding that is a gross deviation from reasonable care, and that he understood that risk was there and he consciously disregarded it, that would be an example of a wanton murder. So just to go back to this, if you believe that he intentionally murdered Christopher Jones and or Maurice Gordon and or Larry Ordway, or you believe that he wantonly murdered them, so the same with the stabbings, like that he was engaging in conduct that he didn't intend to cause murder, but it was such conduct that one would know could cause murder, that he knew it could cause murder, and that he did it anyway, and a reasonable person wouldn't continuing to stab somebody. That would be an example of a wanton murder with a knife in this circumstance. So if you believe that he intentionally murdered, let's just say Maurice, that he intentionally murdered Maurice, or some of you believe that he wantonly murdered Maurice, all you have, because you see that this is an or situation, as long as all of you believe.
Mm-hmm.
So as long as you all believe that it was intentional or wanton, then all of you believe it was murder, obviously beyond a reasonable doubt. So to start at the top, because I know this is really complicated, but I don't want to think that I could have explained it better, and I just failed to. So in Jefferson County, on the date in question, by himself or in complicity with others, he killed Maurice Gordon by stabbing him with a knife. And we went over the complicity instruction earlier. That it was intentional or that it was wanton. So as long as you all agree that it was murder, then you can sign the verdict form for murder. Now, there is a sub part down here in your instruction for example on page 14. So the foreperson would sign either not guilty or guilty. So that part, you have to sign one of these, not guilty or guilty. Then, if you found him guilty of murder, you add in there if you agreed all 12 that it was intentional murder. So your choices on each of the murders is either not guilty, no more signatures, or guilty, and then maybe you all agree it's intentional and you sign there, or you don't all agree it's intentional and you don't sign there. So one of these top two has to have a signature, and then it's up to you as to the bottom whether it is in agreement that it's intentional. I apologize that our state gives, these are the instructions that we have. All right, so those are for each of the counts of murder. Now, if you don't find him guilty of murder, you go on to manslaughter in the second degree. If you do find him guilty of murder, you skip the manslaughter in the second degree. So it's murder, or it's manslaughter, or obviously not guilty, but you wouldn't find him guilty of murder and manslaughter for the same victim. It's one or the other. Now, you only go to manslaughter in the second degree if you have found him not guilty of murder. So if you do, you will see that the main difference is that there's no intentional on there. And that in the second clause, it just says that he was acting wantonly. So that A is he killed Maurice Gordon by himself or in complicity by stabbing him with a knife, and B, that in doing so, he was acting wantonly. So it omits the intentional and it omits the grave risk of death to another, etc. But you don't get there unless you found him not guilty of murder. And I believe, obviously, that we have proven, for all the reasons I've stated, that this was an intentional murder. Now, there are 3 more charges. We have abuse of a corpse. And as you can see, that instruction defines each of the elements as on the 22nd day of May, 2016, he, alone or in complicity, placed the body of Maurice and the body of Larry in a yard off an alley and attempted to burn it, that he had no legal authority to do so, and that in so doing, he treated each body in a way that would outrage normal family sensibilities. I think that's obvious. The other, well, here is Jacory describing his knowledge of this. And he told you the bodies were burned? Did he tell you where he dumped them? West End somewhere. Then the last one we haven't discussed is tampering with physical evidence. You have to find that on May 22nd, he, acting alone or in complicity, destroyed, mutilated, concealed, removed, or altered items from the North Height address, including a pink blanket or the knife or the back seat. If you believe that any of those items were tampered with, then this would come into play. That he did so because he believed that an official proceeding may be pending. That would be the investigation and prosecution. And that he did so with the intent to impair the availability, so that he burned the bloody clothing so that police couldn't find them and that we couldn't bring them into this courtroom. He ripped out the back seat so that police couldn't test it. We couldn't bring it into this courtroom.
Who's driving the car? Where do you go to?
We're going to like different dumpsters. Dumpsters on fire.
Why different dumpsters?
Just to spread evidence.
What type of evidence?
It could have been clothes, it could have been, you said, sheets on it, some of it was evidence.
And was it stuff with blood on it?
Yes,
What did you all do with that stuff?
it was took to a dumpster and they burnt the stuff up.
And that is how you know he is guilty of tampering with physical evidence. I have one last slide to show you.
Once it presented, balls pretty much blurred. Just
Jacory Taylor was 17 when this happened. He's 25 today. Anwan Carter was 15 when it happened. He's 22 today. They've both been to prison. They have both paid a heavy price for not having the courage, confidence to stand up to that man. Nothing compared to the price paid by the victims, obviously, but a price nonetheless. Brice Rhodes preyed on this group of children. He killed an innocent man for no reason. Then he killed 2 children for a horrible reason, because they confided in their mother. There is no other explanation, no other possible motive or defendant to explain why those children were murdered so horrifically. Please bring this 7-year nightmare to an end and find Brice Rhodes guilty of these murders. Thank you.
Ladies and gentlemen, at this time we are going to draw who our random jurors will be. Counsel, would you all mind to come up? Thank you all. All right, I'm going to tell you who the alternate jurors are. I'm sorry, John, would you mind to move that easel? All right, so I have drawn randomly, literally out of a glasses case, our two alternate jurors. Those two of you, I'm going to ask you to remain seated. The rest of you will go with Deputy Mills back to the deliberation room. And Deputy Mills, I just need to swear you, please. Do you swear that you will keep the jurors together and allow no person to speak to or communicate with them on any subject connected with the trial, and you will not do so yourself? I will. All right, thank you. So the two jurors who will not be going with Deputy Mills are a juror ending in 8801 and juror ending in 9462. So if you all could just stay here, please. The rest of you will follow Deputy Mills.
Can we take this?
Are we allowed to take this?
We can take.
No, your notepads have to stay here.
So the only thing we can take is this. Correct.
Cannot take your notepad with you. I said that. Yeah, sorry. I did say that at the beginning as well. And just remember, you'll have one copy that you'll have the four-person sign. All right, for the two alternates, can you all come up here? And counsel, you can come up as well. The camera will need to go off now. All right.
Yeah, thank you.
All right, so we are going to go ahead and let you all go since I have your contact information. But like I said, there's a slight chance, something could go wrong. We could need one of you to come back. So in the meantime, you remain under oath as a juror in this case, and you remain subject to the admonition, which I'm going to read one more time just to be clear. You must decide this case based solely on the evidence presented within the four walls of the courtroom. You must not use internet search engines, websites, blog, or any other electronic tools to conduct any research, post information, or help you deliberate. During the course of the deliberations, do not communicate online with anyone connected to the trial, including witnesses, lawyers, other jurors, experts. And if you accidentally encounter any information about the case from any source, immediately bring it to the attention of the court. The other thing that I'm going to do is because I think what I'm probably going to do is just call you all when we have a verdict, since I've got your information, and then you'll know. I will call you and say, hey, we have a verdict. You're officially relieved from duty. And then if you want to know what it was, I can share that with you as well. Okay. All right, so you all are free to go, and the next time you hear from me will hopefully be me telling you that we have a verdict and will not need you, okay? All right, thank you.
Thank you.
And you all do not need to go to the jury pool room. You can go straight on out. Thank you. Do we have anybody that might be able to just kind of watch them walk to their car?
What do you need?
I'm wondering if we have somebody that can just kind of observe them walk to their car.
Sure, which ones?
The people who just left.
Okay, I'll have to catch up with them.
Okay, well then let's go. I mean, you all also have walkie-talkies. Maybe you could call down to the first floor or something. All right, Mr. Griffith and Commonwealth. I have your all's phone numbers. I do not have your co-counsel's phone numbers. I have Mr. Cunningham's. But typically what I'll do is send a group text to all of the attorneys when there's either a verdict or a question.
Traditionally, what happens with Mr. Rhodes is to stay in the courtroom. Does he go back?
No, we'll let him go back, we'll let him stay up here for a while. Who knows? We might get a verdict pretty soon. But it doesn't really matter to me, honestly.
I don't think he ever really had food. Did you ever really get a meal?
Okay.
If there's any chance
I mean, the jail's not going to deliver food on demand, Mr. Griffiths. I don't know if you've met our jail. But you all are welcome to get him food.
Great.
Honestly, I shouldn't say that. They probably would.
No, I totally
But I bet Mr. Rhodes would. Yeah, I know. They wouldn't be happy about it, that's for sure. Thank you. I got it. All right. 433. 434. I see it now.
Sorry, it's a new
Okay.
number.
It's okay. I got it. I'm just going to go ahead and put you all in here.
Yeah, that's on the road.
But that's one by the snippet block. Better to work, organize that stuff and then have to work.